Delivery of order item number 1.
For reasons mentioned in the order, the petitioner Alamali is allowed to go on bail of rupees 50,000 with 2 sureties of like amount, subject to satisfaction of special NDPS judge Kamrup Metro with certain conditions mentioned in the order.
Obliged.
May I please? I beg to mention item number 40, my lord.
40.
40, my lord. Legal counsel, Mr. A.U. Ahmed, my lord, is out of station, my lord. He instructed me to for taking time, my lord.
Heard Mr.
A.K. Azad.
A.K.
Azad.
Azad, learned counsel. You have informed the other side.
My lord. I have.
Okay. Learned counsel for the petitioner who submits that the conducting counsel is out of station and prays for an adjournment on that ground. The prayer is allowed. Let this matter be listed after 2 weeks.
My lord. Obliged.
May it please the lordship. I beg to mention item number 31, lordship. See, conducting counsel Ace Bora is out of station, lordship. Meta may adjourn for the day, lordship.
Heard Mr.
P.P. Phukan.
P.P. Phukan, who prays for an adjournment on the ground that conducting counsel Mr. H. Burwa is out of station. Considering the ground, the prayer is allowed. Let this matter be listed after 2 weeks.
Lordship. Obliged.
Please, Your Lordship. I beg to mention item number 4, Your Lordship.
Yes,
This is my prayer for pass over the matter for the day, Your Lordship. Any date, Your Lordship.
you will not get a date.
Any date, Your Lordship. There's some personal problem.
Heard Mr. A.A.R. Karim, learned counsel for the petitioner who prays for an adjournment on the ground of personal difficulties. Considering the ground, the prayer is allowed. Let this matter be listed after a week.
Interim order shall continue.
The interim order shall continue till next day.
Obliged, Your Lordship.
May it please your lordship, with the consent of the other side, I beg to mention item 5. Lordship, learned counsel for the petitioner, Mr. S.P. Das, would not appear due to some personal difficulty.
Heard
So,
Mr.
A. Alam.
A. Alam, who submits that the conducting counsel for the petitioner has some personal difficulties and on that ground he prays for an adjournment. He also submits that the learned counsel for the respondent has been informed and he has no objection to the said prayer. Hence the prayer is allowed. Let this matter be listed after a week.
Obliged.
May I plead, Your Lordship? I beg to mention item number 11, Lordship. Matter may be fixed after 1 week, Lordship. 1 or 2 weeks, Lordship.
Why are you praying for?
I will inform to the respondent, Lordship.
No, why are you praying for adjournment? Ground, what is the ground?
Some difficulties is there.
Heard Mr. What is your name?
S. Hawk, Lordship.
Heard Mr. S. Hawk, learned counsel for the petitioner. You have to inform
Yes, Lordship. I will inform.
you have to first inform, then make a mention. We will allow your prayer. You go and inform first.
Your Lord.
Otherwise, whenever this matter is called, it is only item number 11.
11, yes.
We will allow your prayer, but you have to first inform.
Lordship.
Item 2.
Nobody is there. What is to be done? We'll take it up after some time.
After some.
After.
Item 3.
After some time.
After.
Item 6. Item number 6.
Who is a Joe?
Six.
Cover. This one. I know.
Item number 6, none appears for the party, none appeared for the petitioner on call. Ms. N. Das, learned additional public prosecutor is present. Let this matter be listed after a week.
Item 7.
Hello.
Item number 7.
Yeah, please, your lordship. Lordship, final report has been submitted. And the matter has become infrastructure.
Factuous. What is your name?
P. Dev. On behalf of SP Roy.
Third, Miss P. Day. P. Day.
P. Dev.
P. Day.
Dev.
Learned counsel for the petitioner who submits that this criminal petition has become infructuous as final report has been submitted in Latasil PS case number 188/2021. Considering the submissions made by learned counsel for the petitioner, this criminal petition is disposed of on becoming is dismissed on becoming infructuous.
Item 8. Item number 8.
Non appearance, lordship. In this case, scan copy was called for.
Whether scan copy has arrived,
The scan
Yeah.
copy. was-
scan copy has sent.
Eight. 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 Timing goes.
Is there any interim?
Status, scan copy of the CD and status report was called for. Private respondent took time to file affidavit.
None appears for the petitioner on call. It appears from record that on last 3 occasions, the petitioner was found absent on call. It appears that the petitioner is no longer interested in pursue this matter. This criminal petition is accordingly dismissed for non-prosecution.
Item 9.
Lordship, my senior is on legs in another court. Kindly pass over the matter for a time being.
I bring item number 2.
May I please your lordship? Lordship, in this case, lordship, the petitioner is in custody since last 239 days. Lordship, may kindly come to page number 47, lordship. This is a case, lordship, registered under section 376, subclause 1, lordship.
Page number,
Page number 47, lordship. Before the FIR, lordship may kindly peruse the order dated 8/11/2023, passed by the honorable court.
earlier it was rejected.
No, lordship. Here, lordship, what had happened, lordship, direction was given as because, lordship, the case was stuck in the lower court at one particular stage. Therefore, lordship, this order was passed. Lordship, may kindly peruse the last part of page number 48, lordship.
Yes,
May I read the last two paragraphs, lordship, page number 48.
yes.
It also appeared from the record of the case of the record of this court that on 26/10/2023, this court directed the learned additional public prosecutor to seek instructions from the superintendent of police regarding the fact of the case as to why the administration has failed to produce the petitioner physically before the learned committal court when it was so directed by the learned committal court. Today, the learned public prosecutor has submitted that he has been informed by the officer in charge of Mankaso police station that the petitioner has been regularly produced before the learned committal court through video conferencing. However, he was not produced physically before the committal court. On perusal of the copies of the order passed by the learned committal court on 29/2023, 4/10/2023, and 7/11/2023, passed in PRC case number so and so, it appears that the committal court has been repeatedly issuing directions to the jail authority for production of the petitioner before the learned committal court so that the case may be committed to the Court of Sessions as South Salmara. However, in spite of repeated directions, the said order has not been complied with. The petitioner was only produced through the mode of video conferencing. In view of the facts of the circumstances of this case, this bail application hereby disposed of with a direction to the district administration South Salmara to physically produce the petitioner before the learned committal court on the next date fixed on 20/11/2023, so that the case may be committed to the learned court of Sessions as South Salmara. The petitioner may thereafter approach the learned court of Sessions as South Salmara and pray for regular bail before the said court, if so advised. With this direction, lordship, this bail petition was disposed of. Subsequently, lordship, may kindly come to page number 50. Thereafter also, lordship, on two subsequent dates, he was not produced physically, but however, finally, he was produced physically and lordship case was committed and he preferred one bail application before the learned sessions. That order, lordship, may kindly find at page number 54. Page number 54. Annexer 16.
Yes,
Today, the case was fixed for hearing on the pending bail petition number so and so, which White which the bail has been paid for the accused so and so. The case at present is pending at the stage of consideration of charge. Earlier, police, after completion of investigation, has forwarded the charge sheet against the accused under section 376(1), 506 IPC. It is also, it is the case of the accused that he was arrested on 19/6/2023 in connection with this case. That as the IO has completed investigation, he may be granted bail. That the accused is 42 years old person and he is the only earning family members. The learned counsel appearing on behalf of the accused submitted that the accused may be granted bail as the case is pending at the stage. The learned PP, while objecting the bail petition, submitted that the alleged victim, who is Deep and Dam, is under threat from the accused, and if the accused is allowed to go bail at this stage, then the trial of the case will be hampered. The learned PP prayed that the accused may not be granted bail till recording of the evidence of the alleged victim. I have perused the case records. The case record contains the statement of alleged victim recorded under section 164 CRPC and the statement of other witness. On 8/11/2023, the Honorable Guwahati High Court in bail application number so and so observed that the petitioner may thereafter approach the Court of Learned Sessions Judge South Salmara and pay for regular bail before the said court if so advised. At this stage, I have considered the material on record. The case was started after lodging the FIR with the allegation that on 19/10/2020 at 11 p.m. when the Deep and the granddaughter of the daughter-in-law of the informant went out to attend nature's call, then the accused along with another took her forcefully near to a bamboo grove and raped her. As mentioned above, the police has forwarded charge sheet in the case against the present accused on bail. Considering the material on record, this court at least is not inclined to release the petitioner on bail. I have been submission is that lordship. The petitioner is in custody since last 239 days. Investigation has already.
Now, whether the victim has been examined,
No, lordship.
but there is an observation after examination of victim.
Lordship,
Because-
scan copy may be called for, Lordship, scan copy of the
Otherwise
case.
also, scan copy may not be required. The observation is that the victim is under threat from the accused.
Lordship,
Lordship, of the record, lordship, although lordship, I'm not producing certain documents, lordship, as because lordship, this will create another trouble for the, create trouble for the informant, lordship. Here, lordship, in what had happened, lordship, there were some land dispute. And out of which, lordship, FIR was lost. And lordship, in the FIR, lordship, if lordship kindly come to page number, the FIR, lordship. It's a very small FIR, lordship may kindly come to page number 19. 2 persons were named, lordship. And lordship may kindly come to the last part of page number 19, lordship. Short FIR, may I read the FIR, lordship?
No, you come directly to last part.
Last part. I
Second-
went to sir, and on reaching the bamboo garden, I red-handedly caught the accused persons. As such, the accused number 2 ran away from there. Accused number 2, Abul Qasim. Lordship may kindly see accused number 2, Abul Qasim. When the accused person came to know about my losing the FIR, the accused person at 11 AM gave me life-threatening. Now, lordship, as per the version of the informant, 2 persons were present. One, lordship, the accused number 2, whom he saw running away from the place of occurrence. Now, lordship, may kindly come to the charge sheet, lordship. That is at page number 26. Once again, lordship, I am reading the last paragraph on this. The first part, lordship, is the brief of the facts, which is there in the same as each FIR. During the course of page number 26.
Yes.
During the course of investigation, visited the PO, examined complaint and other witnesses. The victim medically examined and recorded her 164 statement under 164 CRPC through trained down teacher. In the course of investigation, the case is well established under section 376(1). Earlier, lordship, it was registered under section 376D. 506 IPC against the accused person secondarily. Thereafter, after completion of investigation, the case submitted in charge sheet against the accused number 1 so and so.
Accused person, second.
Only one person came, Lordship, here.
So what is your submission?
My submission is that, Lordship, I'm not pressing the merit of the case at this stage, Lordship, as because those will be decided by the learned court below at the time of trial. Here, Lordship, 239 days, the petitioner is in custody. And Lordship, moreover, Lordship, police has already completed the investigation.
No,
This
no.
is not a
Yes,
case.
the observation is that there is a threat from the accused towards the victim. And on that ground, it has been rejected.
Lordship.
And the observation is that after recording of whether that observation is there, that after no, the state, we
164,
evidence,
reference of 164 statement is there, Lordship.
no, the evidence of victim is yet to be recorded.
Yes, Lordship. And so far, the threatening part is concerned, Lordship. Lordship may kindly peruse the documents, Lordship, which just now I have furnished, Lordship. Otherwise, Lordship, next case is fixed for recording her statement, Lordship. In that case, Lordship, my alternative prayer would be, Lordship may kindly call for the scan copy of this case. Fixing the next date, Lordship, after 15th of February, Lordship. Let it be on 21 or 22. I will produce one certificate.
No, we will not call for the scan copy. We will call only the status.
Yes, Lordship.
Status.
Status, Lordship, and Lordship may kindly permit me to produce the certified copy of the deposition of the victim, Lordship, if in the meantime it is recorded. As because, Lordship, next date is, Lordship, on 12th, I think.
That you will be free to do so.
Yes, Lordship.
No other.
No need to. Yes, Lordship.
Heard Mr.
Am I?
M. Ahmed, learned counsel for the petitioner. This application for bail by the petitioner Sikandar Ali has been filed under section 439 of the Code of Criminal Procedure. Stop. The petitioner has been detained behind the bars since 19/6/2023. That is for last 239 days. It is submitted by learned counsel for the petitioner that by order dated 4/12/2023, learned sessions judge had rejected the prayer for bail rejected the application for bail made by the present accused in sessions case number 139/2023 on the ground that the public prosecutor had objected to grant of bail on the ground that the victim, who is a deaf and dumb girl, is under threat from the accused, and the evidence of the victim is yet to be recorded. Stop. In view of above, let a status report be called for from the Court of Learned Session Judge, South Salmara, as to whether the evidence of victim has been recorded or not. Let this case be listed again on
21st.
21st February. 21st February for the status report from the Learned Trial Court.
Hi, Lord.
Landing item number 3.
I'm sorry, my lord, I was not. Well, it's a 482 application, my lord, regarding maintenance, my lord. The lordship will find, my lord, page 21, my lord. Page 21, my lord, the respondent number 2, my lord, who filed an application before the family court, my lord, for maintenance, my lord. Now your lordship may turn to page 33, my lord. My lord. Lordship will find the order, my lord. This is the petition filed under section so and so, praying for maintenance allowance from the opposite party. Register the case and issue notice to the opposite party as why maintenance allowance should not be paid as paid
into
for.
Agor case. Rakhi. Yes.
Yes, now lordship may turn to page, my lord, 38 for a once, my lord. Page 38, my lord. Well, this is the order on, my lord, passed on 01/08/2022. Petitioner is present, opposite party is absent. Perusal of the case record reveals that the opposite party remained absent consecutively for 4 dates, that is since 10/3/2022. And skipping in view the repeated absence of the opposite party, the instant case is proceeded ex parte against him, fixed so and so for ex parte hearing, my lord. Well, thereafter, my lord, lordship may turn to page 44, my lord. Page 44, my lord. My lord. Well, I then, my lord, approach this court, my lord, and file an application, my lord. Page 44, my lord. Well, with a prayer, my lord, it is therefore prayed your honor may please to admit this petition and be pleased that setting aside of the ex parte order on dated 1/8/22 and after setting aside the ex parte order, the case may kindly be decided on merit and proceed the case for the interest of the proper justice, my lord.
On
Well,
which date this petition? has-
Your lordship will see on the left side, my lord, top, my lord, petition number 113, my lord, and below the date is there, my lord, 27/02/23. Lordship found it, my lord. Top, my lord. The round seal, below the round seal, my lord.
Yes. What order was passed?
Now your lordship may turn to page 41, my lord. Page 41, my lord. On the same date, my lord, page 41, my lord, 27/02/23, my lord. Learned principal judge is on leave. Petitioner is present. Since petition number 113 of 23 filed by the opposite party, fixed 26/04/23 for necessary order, my lord. And although this petition has been filed and this order was passed, my lord, thereafter, my lord, I have been not heard, my lord, nothing, my lord, but the court proceeded, my lord, and passed an ex parte judgment, my lord, that your lordship will find at page 47, allowing me to pay rupees 40,000 per month to the opposite party, my lord. That order starts from page 47, my lord, the judgment, my lord. My lord, my limited prayer, my lord, as my lord, I have filed an application before the judge trial court, my lord, for that ex parte order, my lord. No order has been passed on that petition, my lord. So my limited prayer, my lord, that I may be allowed to appear before the court, my lord, and the court may hear me, my lord.
No, but before that, this ex parte order has to be.
Yes,
vacated.
my lord, but no order has been passed, my lord. That's the grievance, my
No,
lord.
now in spite of that, an ex parte judgment has been passed.
Yes, my lord.
There is no prayer for vacating the ex parte judgment.
My lord, to be honest, my lord, that was not there, my lord, and the court proceeded, my
The
lord. that-
relief which is available to you is under 397 revision,
Yes, my lord.
but you have approached this court under 482,
Yes,
which I think is not permissible.
That's true, my lord.
On that you have to satisfy.
My lord, that's true, my lord.
What relief you are seeking in this?
My
case?
lord, one more, only contention, my lord, of this judgment is that, my lord. My lord, in a recent judgment, my lord, 2021 2 SCC, my lord. 2021 2 SCC, my lord, 324, my lord. That is party name is, my lord, Rajnesh versus Neha, my lord.
Yes.
My lord, here, my lord, I'm giving this copy, my lord. Here, my lord, that's, my lord, it said, my lord, that it's a compulsory, my lord, it's a mandatory on the part of the, my lord, the parties to file the affidavit of disclosure of asset.
No, that is okay. But for that, you have to challenge the judgment.
Yes, my lord. But I have challenged the whole proceeding itself, my lord.
All proceeding cannot be challenged.
My lord, your lordship has
Whether whole proceeding,
rightly said, my lord. I understand, my lord.
you have to challenge the judgment because this judgment was passed on 11/7/2023.
Yes. Your lordship has rightly taken the mode, my lord. Actually, my lord, for delay purpose, my lord, he
Because
also
there
can,
would be delay,
yes,
there is a condemnation of delay application
yes,
would be
my lord.
required. Notice would go to the other side. This does not appear to be maintainable.
My lord. So in that case, my lord, I may be allowed to file a fresh petition, my lord, in that.
You
case,
want
my
to
lord.
withdraw this?
Withdraw this.
Heard, Mr. N.J. Datta, learned counsel for the petitioner.
Expert order.
Learned counsel for the petitioner has prayed for allowing the petitioner to withdraw this criminal petition with liberty to file fresh. The prayer is allowed. This case is dismissed on withdrawal with the liberty as sought for.
Yes. Your lordship had rightly catch the point. Because of the delay part, my lord, that. Understood. I am obliged.
Item 10.
Made please, your lordship. Lordship, this is a petition under section 482 CRPC seeking quashing of silture PS case number 1300 of 2022 lodged under section 406, 468 and 420 IPC. Lordship, this is a case between two parties where both of them are legal heirs through a common ancestor. Now, the petitioners, by following the provisions of law, applied for mutation of their name in the land records, which was duly permitted also by the authority by following the prescribed procedure under some land and revenue regulation. And because of that mutation, your lordship, after about 6 months of the mutation order, the instant FIR.
Whether the LCR, scan copy of LCR is there.
It's here, LCR is here.
I have not checked, I can see. Why? LCR is not here. Only one page LCR? I said no.
No, what you have challenged,
Actually, I have challenged only the FIR because no charge sheet has yet been filed.
it is still in
It is still
investigation.
in the
Then
investigation. Lordship, I think call for the.
We can bring the CD
case,
in that case.
case diary would be required.
We'll bring the CD then.
It is there, I think.
No, a scanned copy of the case diary was called for from the court, but that is not possible. It's not charge sheeted.
Not charge sheet.
So we will bring the case diary, Lordship. The order was wrong. নাই করা কেস ডায়েরি স্ক্যান কপি অফ দি কেস ডায়েরি রেজিস্ট্রি পাই এরকম নহয় নি এটা যে এনসিআর 15 একোৱে নাই
Any CDs can copy to us anything.
নাই
No, whether scan copy of case diary is there or not, it is not there.
it is not with us. Let me bring the case diary that was done through the registry, it seems that was mistakenly done.
It would be required
Lordship may peruse the FIR.
because merely perusing the FIR,
Will
No,
suffice,
yes.
will actually the requirement.
whether mere perusal of FIR will do.
Mere perusal of the FIR along with the analogous papers, that is required for quashing of FIR and all. In every case, we need not see the case diary.
Yes.
Here, Lordship will see the FIR if it makes out a cognizable offense. And that is the end of the matter.
Additional affidavit I have filed.
FIR can go.
Where is the FIR? At page?
Lordship, FIR is at page number 102, but you have an additional affidavit. I have filed a earlier this honorable court directed to file a proper copy of the FIR. There was some mistake actually that was filed.
Asset. But
Page number 102, your lordship.
102, I don't have.
It is a translated copy of. the-
Translated copy, your lordship.
Yes,
May I read, your lordship?
yes.
This FIR was lodged by Azizur Rahman Lashmi. In the meantime, he has expired, your lordship. Now his legal heirs, they have filed an impleadment petition and they have been impleaded in the instant case, your lordship. After filing of this criminal petition, he had expired.
It took him. Whatever, fine.
May I read, your lordship?
Yes, yes.
The below scheduled property was the joint property of his father, Saeed Ali and Fatima Bibi. On 24/11/2019, the said Fatima Bibi sold her property, which is half of the property of 4/2, that is 2/1.2, 2 bigha, 1 kata and 2 chatak to Makabbir Ali and Khaddar Ali. But my paternal property of 2 bighas, 1 kata and 2 chatak remained as such. And we are enjoying the possession and ownership of the said property as our ancestral property by regularly paying the land revenue to the government. In the meanwhile, the below mentioned accused number 1 to 18 in conspiracy with accused number 19 and 20 for an illegal gain and in exchange of huge sum of money had mutated their names in our line in the third arrest by tampering the government records. We have come to know about the same recently. Due to such type of forgery committed by the accused persons, I'll be deprived from my ancestral property and will suffer irreparable loss and injury. Now, Lordship,
Appellant is number 1 in the
Yes.
accused persons list.
all the 18% in whose favor the mutation was done, your Lordship. Lordship knows that for mutation, there is a procedure prescribed under the Assam Land and Revenue Regulation. The parties have to file an application, Lordship, which is at page number,
No, but the allegation is of tampering of the government record. That is the allegation.
yes, government records. Because our name have been included in the records, your Lord, that is what they are saying tampering. This has been done in accordance with the law, and there is a provision. If someone is aggrieved by mutation order passed by the learned settlement or assistant settlement officer, there is a provision to file an appeal before the deputy commissioner, your Lordship. If an authority, your Lordship, gives an order for mutation, there is an appellate provision if someone is aggrieved, and by way of mutation, you cannot take away their property. Lordship knows that there are several judgments where say that mutation is only for the purpose of collection of land revenue. It does not confer any title, your Lordship. Otherwise, in the FIR, they are saying that they are in possession of the land, they are enjoying their land, but they have
Whether stay was granted in this case.
Lordship.
Stay of investigation was granted.
No, because investigation
Investigation is on.
not state, your Lordship. Because down.
So let us call for the case diary.
Lordship.
By this time, the FIR was lodged on
FIR was lodged on, your Lordship,
22.
Lordship.
So by this time,
18/4/2022.
Let the case diary come because so many allegations.
Only
Of course,
allegation.
In selling part, I think no objection certificate and all are not unnecessary.
No, it is not
The
a case
office
of
gives.
selling.
Uh-huh.
It is only that since our names have been mutated, it
Mutated
is said that we have tempered the government records. Mutation has been done by following the procedure, your Lordship. We have filed an application, a hearing was held, and then the mutation order was passed, your Lordship. I have annexed. Even if they are aggrieved by this mutation, your Lordship, under the Assam Land and Revenue Regulation, there is a provision that they can file an appeal before the deputy commissioner. And by way of mutation, we cannot take away the property, your Lordship. Mutation does not confer any title, any right, your Lordship. Their only fear is that by way of this mutation, we are going to take away their property, your Lordship. Otherwise, on merit also, I will substantiate that we are from the same ancestors. And we have also our property there. We are also in possession of our part of the property. So this is a case of pure civil nature.
Case was registered under
420, 468.
468.
Yes, your Lordship, and 403.
So forgery was alleged.
Yes, that is, they are alleging that forgery.
Let the case diary come
let us
along
see.
with the papers.
Okay. Let us
Both
see.
things, it is case of pure civil nature, Lordship.
Heard, Mr.
MH Lordship.
This is item number
10, your Lordship.
10. Heard, Mr. M.H. Laskar, learned counsel for the petitioner, also heard Ms. Asher Jahan, learned additional public prosecutor. It appears that considering the nature of this case, the perusal of case diary of what is the case number?
Silchar PS case number.
Silchar PS case number
495. No, it is GD entry.
PS case number 1300.
1300
Oblique 2022.
Public 2022 would be necessary for consideration of the instant criminal petition, hence call for the case diary. Fixing
Kachar, so Lordship, we'll take it up 21st of February.
21st February for case diary.
I am obliged, Lordship.
Case diary, I will buy. Because it has 11.
Yes, Lordship.
My land friend sought adjournment, Lordship. Kindly fix a date, Lordship. I'm a respondent side. I'm your Lordship, your respondent side, Lordship.
Okay, heard Mr. S. Hawk,
Yes, Lordship.
S. Hawk, learned counsel for the petitioner who prays for an adjournment. Also heard Mr. B. U. Lusker, learned counsel for respondent number 2. And Mrs. Jahan, learned additional public prosecutor appearing for respondent number 1. Learned counsel for respondent number 2 does not have any objection regarding the prayer for adjournment. Hence, same is allowed.
Fix a date, Lordship, on 20th, Lordship.
On 20, Lordship.
20.
25.
Let this case be listed again on 20 February 2023.
Obliged.
24.
Item 12,
May please, your lordship. I am the wife lordship, the till death, no payment is paid lordship. Balance amount 1,35,000.
Is there any stay?
No.
You go for execution before the magistrate's court.
But the trial court has said lordship, the case is pending before the.
No, but there is no stay. There is no bar in going for execution of the order. What is to be done? The counsel for petitioner is absent. Mr.
N. Ahmed.
N. Ahmed, learned counsel for respondent. None appears for the petitioner on call. Learned counsel for the respondent has submitted that the petitioner has not yet paid any maintenance allowance to the respondent as directed by the
Principal Judge Family Court,
Principal
Borbetta.
Judge Family Court, Borpeta, in spite of the fact that no stay has been granted in this criminal revision petition. The respondent shall be at liberty to pursue an execution proceeding before the learned Principal Judge Family Court, Borpeta, for execution of the order dated 25/11/2022. Stop. Let this matter be listed again after 2 weeks.
Date may be fixed, lordship.
No, you go for execution
Lordship.
after 2 weeks.
Lordship.
item 14,
Item 13, this is a legal aid matter, your lordship, and the present appeal has been filed against the judgment and order of the Sessions Judge Dima Hassau, your lordship.
Paper book seems to be ready. Lordship can take it up for hearing.
No, this appeal is yet to be admitted.
Acha. Oh, it has come up for the first time.
Yes.
But paper book is ready, so I thought perhaps everything is
Paper book
over.
is ready.
I have not.
Item number 13.
No.
13.
Yes, I have this. Seems to be like a paper book. Yes, all relevant materials are here.
Item number 13, heard Miss S. Sharma Majorika, Learned Legal Aid Counsel. This appeal has been registered on filing of an appeal petition by the appellant. Where is the, you have filed an appeal memo? No,
This is jail appeal.
jail appeal. So appeal petition where he
Yeah, legally counsel, yeah.
appellant Bhajan Ravi Das, who has been detained in, where he has been detained,
Lordship, Dima Hasa, your lordship.
in which jail? District jail?
District jail, your lordship.
I hope Dimahasa has a jail for itself.
The petition is
Sub jail, half long. Perhaps it's a sub jail, half long.
he has been detained in sub jail Haflong.
Page number 43, Lordship can see. This is the warrant of commitment of sentence.
Sub jail Haflong, impugning the judgment dated 30/3/2023 passed by the Session Judge, learned Session Judge Dima Hasao in Sessions case number 18/2017, whereby the appellant has been convicted under section 307 of the Indian Penal Code and has been sentenced to undergo rigorous imprisonment for 5 years. And to pay a fine of rupees 3,000 with default stipulation. The appellant has also been sentenced under section 325 of the Indian Penal Code and has been sentenced to undergo rigorous imprisonment for 3 years and to pay a fine of rupees 2,000 with default stipulation. He has been also sentenced to, he has been also convicted under section 323 of the Indian Penal Code and has been sentenced to undergo simple imprisonment for 6 months. The appellant has also been convicted under section 447 of the Indian Penal Code and has been sentenced to undergo simple imprisonment for 2 months. Stop. This appeal is admitted for hearing. Call for the LCR as learned additional public prosecutor has appeared. No formal notice need to be issued to the state respondent. Let this matter be listed again after 4 weeks.
After receipt of the LCR, yes.
After 4 weeks,
4
after
weeks.
receipt of the LCR.
4 weeks.
Oblation.
Item 14.
This is also a jail appeal. A. Fukon is the amicus. Lordship can admit it and.
Amicus has been appointed.
Amicus has been appointed, it seems, from the registry.
Mr. A. Fukan, learned amicus curiae, who has been appointed in this case, is not found on call. Heard Miss S. Jahan, learned additional public prosecutor.
Arunav nahi.
This
Whether that A is Arunav, Lordship can see the full name. Oh, copy more pola. Actually, it was made a practice that amicus curiae's name should be fully shown. But
yes,
here it is not fully shown.
There are-
People get
Confused.
confused.
which A. Fukan has. Arunav
Arunav Fukan,
Arunav Fukan.
Lordship. She will intimate.
This jail appeal has been registered on receipt of an appeal petition by appellant Arun Gwala, who has been detained in district jail Difu and who has impugned the judgment dated 25/5/2023 passed by learned Special Judge Pokso Karbi Anglong in special case number special in POXO case number 22/2018, whereby the appellant has been convicted under section 313 of the Indian Penal Code and has been sentenced to undergo rigorous imprisonment for 7 years and to pay a fine of ₹5,000, and in default of payment of fine to undergo simple imprisonment for 2 months. The appellant has also been convicted under section 6 of the POXO Act, 2012, and has been sentenced to undergo rigorous imprisonment for 10 years and to pay a fine of ₹10,000 in default of payment of fine to undergo simple imprisonment for 2 months. This appeal is admitted for hearing.
Mr. Fukan is here.
Lordship, apologies, I was in like
Okay, show his attendance. First line to Katidyo.
Hmm.
Mr. A. Fukan is heard, Mr. A. Fukan, as well as Ms. S. Jahan. This appeal is admitted for hearing.
Lordship will send the notice. It seems to be a POXO matter. As per Deepak Nayak.
Okay, issue notice to the to whom notice will go?
Victim or the guardian or the
Guardian of the victim.
support person. Any of the three. Na copy bono hai na jail appeal na.
Where the address,
It will be in the FIR. Of course, that will not be there again. Registry will find out the address and send it. Informal code power. Na to jail appeal. In the judgment, Lordship, no, Lordship will not get there also.
judgment, it will be concealed.
Let the LCR come, then Lordship may issue the notice. Because registry will also not be able to find out.
All for the LCR. As this is a case under POXO Act, there is a requirement of notifying the victim or the guardian of the victim or support person of the victim. However, at present, the details of the victims are not available on record, and therefore notices would be issued to the victim, guardian of the victim / support person of the victim in pursuant to the mode prescribed by a division bench of this court in Deepak Nayak versus State of Assam after receipt of the LCR. Let this case be listed after 4 weeks.
This procedure is done in many cases because without LCR we won't know the
Okay.
address.
after receipt of the LCR. List this case after 4 weeks.
Lordship.
BPM Lordship.
Item 15.
Right. Mm. 15, shut up. Appeal.
My please, your lordship. This is appeal against conviction, your lordship. In earlier occasion, LCR was called for in this case. And the
Any?
estate has already filed objection for it.
I mean, objection is it.
In this case, one bail petition is there, your lordship, that has not been listed today. I
Hmm.
500, I have 507, your lordship.
It has to be listed.
Perhaps I file is there. It's there,
Yes.
I think. But not listed.
Why it is listed? It is yet to be admitted.
I think for that reason only.
So we'll admit the appeal.
Lordship, yes.
LCR is there.
No,
Okay.
as per service,
Heard
Both-
Mr. A.M. Khan, learned counsel for the appellant. Also heard Miss S.H.
S. Jahan.
S. Jahan, learned additional public prosecutor. This appeal
16 to Kuru. Sapna, 16 Kuru.
where is the memo of appeal? This appeal has been registered under section 374 on filing of an memo of appeal under section 374 within bracket 2 of the Code of Criminal Procedure by the appellant Mosharraf Ali alias Mosarraf Ali, impugning the judgment and order dated 6/12/2022 passed by learned additional sessions judge within bracket FTC Borpeta in sessions case number 91/2022, whereby the appellant has been convicted under section 304 IPC 304
B.
B of the Indian Penal Code and has been sentenced to undergo rigorous imprisonment for 10 years and to pay a fine of rupees 10,000.
it is 06 also.
With default stipulation and 306.
With default stipulation, the appellant has also been convicted under section 306 of the Indian Penal Code and has been sentenced to undergo rigorous imprisonment for 10 years.
No, simple imprisonment for 6 months. Okay. Or he has written it wrongly in the,
It is wrongly written.
oh, in the cost title it is wrongly written.
Yes, it will be.
Fulfill it. Lordship. I stand corrected.
In PS 57.
Arrive for 10 years, yes.
Rigorous imprisonment for 10 years and to pay a fine of rupees 10,000 in default with default stipulation under section 306 of the Indian Penal Code. This appeal is admitted for hearing.
Perhaps 304, there is no fine.
Yes, 304 on
B.
fine line.
Fine, nine, I think.
306 fine is there and 10 years. in prison.
304 only 10 years imprisonment. 306 10 years imprisonment plus
No, but
10,000 fine within default stipulation. This appeal is admitted for hearing. Call for the LCR. Since learned additional public prosecutor has appeared for the respondent, no formal notice need to be issued to the state respondent. Let this case be listed after 4 weeks,
Along with.
along with
I
IA
criminal number 50.
IA criminal number 507/2023.
Item 60.
The Milord for quashing of the Milord proceedings. What had happened, Milord, here, Milord, the wife of the Milord, respondent number 2, Milord, he had purchased a Milord, repossessed vehicle through auction from the Cholamandalam Finance Company Limited. Now, Milord, there was a condition, Milord, the vehicle would be purchased in a as is where is basis. Now, what had happened, Milord? After purchasing the vehicle, Milord, he drove the vehicle from Tezpur to Guwahati. After 52 days, Milord, he lodges an FIR stating that, Milord, one tire is missing, and, Milord, the documents were not in order. Mr. Lordship is aware, Milord, that the documents, Milord, in a repossessed vehicle, the documents otherwise is not in order. In fact, Milord, the auction purchaser had signed an, Milord, indemnity bond stating, Milord, that they, in case of any,
No, who has purchased?
the wife of the respondent number 2, Milord.
Okay.
Now, your Lordship will find
Wife of the respondent number 2 has purchased a vehicle
the wife of the respondent number 2 had purchased the vehicle
from
from Cholamandalam Finance Limited
in auction.
in auction. Your Lordship kindly comes to, Milord, page 50. I'll just, Milord,
Page?
page 50, Milord. Annexure 2.
No, before taking me through the documents, you tell me the gist of the case.
So that is, Milord. Now, what had happened, Milord? In the quotation for bid, Milord, it was, Milord,
Quotation for?
for the bid, Milord. It was bought in auction, Milord. It was the, Milord, condition that the vehicle would be purchased as is where is basis.
Okay.
Milord, that is why they refer to page 50, Milord. Here, Milord, it was a condition that I have inspected the vehicle and I am satisfied with the condition of the vehicle. Now, Milord, thereafter, Milord, the vehicle was sold at a price of 4,50,000. It's a traveler vehicle, Milord. Milord, in the acceptance sale letter, sale acceptance letter also, Milord, she agreed to the conditions, Milord. And in fact, she had also signed an indemnity bond. Where, Milord? They stated that any variance in the documents, because with the if your Lordship knows, once the vehicle is repossessed, Milord, all the documents are not in order, because, Milord, most of the documents are with the original purchaser. Now, Milord, the vehicle was driven from Tezpur to Guwahati. No grievance as such. After 52 days, Milord, this FIR was lodged at your Lordship will find at page 64. Against the law, Milord, the area manager and the regional manager, Milord. Petitioner number was the regional manager and the stating, Milord, they have forged the documents. Surprisingly, Milord, initially, Milord, I was granted interim bail. It was made yesterday. Certain documents were seized, Milord. Now there is not a mention, Milord, as to what documents were forged by us. The amount was deposited in the account of the Cholamandalam Finance, Milord. And there is no scope for us to, Milord, manipulate any documents. Now, Lordship. In fact, if your Lordship kindly, I'll just take you to, Milord, page 68 are the seizure list. There were 3 seizure lists, Milord. Quotation, indemnity bond submitted by, Milord, the auction purchaser. All those were there. Then even below the original documents were also seized. The originals are at page 70, my lord. Then
Already proceeding has been stayed, Lordship. Proceedings are already stayed, Lordship. LCR is yet to come, Lordship.
So LCR has not yet.
No, no. So let the matter come up for hearing any date, either in the last
After
part of.
receipt of the LCR.
Yes, yes.
Lordship may admit it, my lord. Lordship may call for the LCR along with the case diary.
Lordship will have it in the month of
Month of
April
April, my lord, that can be done.
or in the last part of March.
Heard Mr. V. Day. Sorry, R. Day, learned counsel for the petitioner. Also heard Miss S. H. Bora, learned additional public prosecutor, as well as Mr. A. Ganguly for respondent number 2. This criminal petition is admitted for hearing. Call for the LCR. LCR of
PRC 969 of 2021.
call for the proceeding has been stayed.
Stayed, my lord.
Stay.
Call for the LCR of PR. Call for the case record of PRC case number 969/2021 from the Court of Learned Subdivisional Judicial Magistrate S number 2 Kamrup Metro Guwahati, and list this case after 4 weeks after receipt of the LCR for hearing.
Only thing, my lord, the case diary may also be called for, my lord, along with the, my lord, case records.
The case diary of which case?
Cotton Bazar PS case number 608.
Case diary of Paltan Bajar PS case number 608
my lord.
/2021
No, my lord,
No.
2017.
17.
/2017. We also called for, along with the case record of PRC case number 969/2021.
Interim order, may.
The interim order shall continue till next day.
Deeply obliged.
Item number 9.
My pleasure, Lordship. My lord, here is the issue, is a very small issue, my lord. Only one point to be record to be adjudicated, my lord. Page 49 is the seizure list, my lord, containing of FSL report, my lord. And seizure list, my lord, page 22, my lord. It is Page 49, my lord, is the FSL report. Full line to be. Result part, Lordship, can be seen, my lord. Exhibit so and so is the gave positive test of codeine so and so, and placement in the exhibit are to be 169 to 1 and 169.63 gram respectively. 2 bottles have been sent for FSL now. Out of 1,000 bottles. Now, Lordship will see, they have seized, my lord, not from me, practically, my lord, at page 22, my lord. Total number of bottle, my lord, 996. Assuming it is a 1,000, my lord.
Page 22.
Only small paragraph, my lord. NCB, may I read, my lord? NCB team in the presence of the independent witnesses sees the witnesses driver so-and-so and 2 suspects of the so-and-so joint command completed the both the batch and sample for the batch number is the drawn from so-and-so for the batch number so-and-so was drawn from the exhibit P food. Each of the sample were kept for the LSA envelope and containing the sample batch so-and-so as well as S number 1 and D number 1 respectively. The evidence containing the sample of so-and-so S two number of original. All the samples were kept in the NCB in number 2. Signature of the 2 suspects, seizing officer and 2 independent witness so and so. So altogether there was a 1000 bottle, my lord. 2 bottle have been sent for FSL. My lord. Now, my lord, my only issue is that, my lord, the learned court below by the impine order, my lord, the charge was framed under section 21C, my lord. If it is so, my lord, I have given fraction, my lord. Worship will kindly turn to page, what was it? Page 12, my lord. Roman 3, my lord. I have given fraction, my lord, how it has come, my lord. Because it was seized in a milligram, my lord.
Page 12.
Page 12, my lord, of my criminal petition.
Yes.
For that learned court below to fail to appreciate prima facie complaint petition and seizure of FSL report so and so number 1 ABCDE. As per FSL report, each bottle of cough syrup having codeine contains 163 to 169 mg milligram, my lord. Codeine. If 1 bottle of cough syrup contains 169 mg codeine, then 1000 bottle will be 1000 into 169 mg, meaning thereby 1169 mg and 169 mg converted to gram, it will be 169 gram. It is a intermediate quantity, my lord. It has to be 2B, my lord. And now, my lord, I came to know this morning, my lord, the date is fixed for 15 or 14, my lord, for judgment. My lord. So lordship has to restrain, my lord, till the matter is taken up by your lordship.
No, I am not getting your submission.
My
Your
submission is that, my
that
lord.
FSL report
FSL
says
report
that one
bottle
69 milligram codeine is found. Therefore, it is not commercial quantity.
quantity because 1000 bottle is
But you
there.
have to take the mixture, total of the mixture, not
No, my
not the,
lord. So far, we'll have to go by a FSL report, my lord.
no.
They cannot add, my lord.
You are not right.
No, I may not be right at this moment, but whatever document is available, my lord.
No,
They have
you
not
go
taken-
through what Hira Singh's judgment
Yes,
says.
Yes, that is
But Hira Singh is correct, my lord. But well, trial court, my lord, did not take into account, my lord, because there is no
No, whether mixture
Mixture has not
is
been
less
taken
than
into account.
commercial. Total weight of the mixture is less than commercial
my
quantity.
lord. Mixture, my lord, it has not been taken into account because there is no such document. The particular weight of 1 bottle, how much? Had it been there, my lord, they have weighted mixture, then otherwise. Because FSL report, my lord, basing on this document, my lord, case is proceeding, my lord. And charge was framed, my lord, 22C. If the mixture is taken, then otherwise, my lord.
No, FSL report is with regard to qualitative test only, not
My lord,
quantitative
what
test.
is the actual ratio of that particular contraband? That is true, my lord. But is there any document with the DRI, my lord, showing that the quantity of all the mixtures have been taken into account while framing charge, my lord? Only that point is to be
Where is
decided.
the seizure list?
Seizure list, my lord, I have annexed, my lord. Lordship will see at page, it starts, my lord, a big page, my lord. It starts from, my lord, page 19, Panchnama. Then lordship will see page 21. Operative part, my lord.
1,000 bottles were seized.
1000 bottle were seized.
Each
But
bottle contains how much?
that has not been taken into account. That is my case, my lord. If it had been taken, my lord, I would have not come.
There is no mention.
No mention, my lord.
How
I
much?
have gone through all the records, my lord. But I did not find, my lord, that mixture quantity they have mentioned about or weight anything, my lord. So may I pray at this stage, my lord, since the date is 14 or 15, my lord, let the learned court below, my lord, restrain from passing any order till the decision of the case. In the meantime, my learned brother will confirm from the record whether total weight was taken into account or not. If it is taken into account, then I have no case. If it is taken into account. So it has to be ascertained by them only from the record. So my lord, 14 or 15 is the next date, my lord. Till then, my lord, one date, my lord, learned court below may be restrained from passing any order. The moment he has passed any judgment, my lord goes.
I'll dispose it of today itself. Your
Lordship,
criminal
lordship, that
petition,
will-
if you are ready.
I am ready, my lord. I am ready otherwise.
Your case is that it is not of commercial quantity.
My lord, intermediate. Because, my lord, if they have, because there is no mention, my lord, about the quantity, my lord, the
Yes,
total weight.
that is your submission.
Only that much. my lord. If it is, the weight is been taken into account, then I have no case, fairly I am submitting your lordship.
Yes, Mr.
Lordship, admittedly, 1000 bottle has been
Yes,
seized.
yes, that is.
And
What
Lordship,
was the,
one bottle contains 100 grams.
is there anything, any
Lordship, it is,
any mention in records?
no, Lordship, even then, suppose it is not mentioned, Lordship. Lordship, the Hira Singh said, Lordship, may kindly please to, I've given the citation. Lordship, that was a reference by Michael, that case, Lordship, then the reference was answered. Lordship may come to paragraph 10. Concluding page, paragraph 10.
Judgment is all right, my lord, let them say from the.
No. Let me submit.
Let him submit.
Lordship, paragraph 10.
Yes.
In view of the above, and the
Page,
reason
page
is,
number?
Lordship, last page.
Yes.
Paragraph 10. In view of the above, and for the reason stated above, reference is answered as under the decision of this court in case of E. Michael Raj Supra, taking that view that in mixture of narcotic drug or psychotic substance with one or more natural substance, the quantity of natural substance is not to be taken into consideration while determining the small quantity or commercial quantity of narcotic drug or psychotic substance, and only the actual content by weight of the offending narcotic drugs, which is relevant for the purpose of determining whether it would constitute small quantity or commercial quantity, is not a good law, not a good law. Then paragraph 2, in case of seizure of mixture narcotic substance with one or more natural substance, the quantity of natural substance is not to be excluded and to be taken into consideration along with the actual content of weight of the offending drug while determining the small or commercial quantity of natural narcotic drug or psychotic substance. Then 3, section 21 of NDPS Act is not stand-alone provision, must be construed along with the other provision in the statute, including provisions of NDPS Act, including notification dated 18/11/2009 and dated 19/10/2001. 4, challenge to notification 18/11/2009 and note 4 to the notification dated 19/10/2001 fails, and it is observed that and held that the same is not ultra vires to the scheme and relevant provision of NDPS Act. Consequently, the writ petition and civil appeals challenge to the aforesaid notification is dismissed. Meaning thereby, if the narcotic substance is small quantity, then entire content of the bottle is to be taken into consideration. Here, Lordship, admittedly 1000 bottle has been seized and each bottle contains 100 grams.
Where is that?
Lordship, it is Lordship.
That each bottle contains 100 grams. Somewhere it has to be, it should be there. In the instant case.
Lordship may come to page 20.
Yes.
As per the label, each bottle contain codeine was put 10 mg, quantity sounds and 4 mg
Ingredients.
and date of manufacturing by Adobe Sensor MRP 140.25. That is the description on the bottle. On reasonable belief, the offense has been committed under section 8C of the Edward so. The codeine-based phencyl cough syrup bottles were seized under section 43 DPS Act. On asking the earlier had a mobile number so and so and ID so and so. The total, lordship, last paragraph, all these above mentioned articles, documents were also seized under section 43 of the NDPS Act. All 5 packets were marked as P1, P2, P3, 4, P5. On counting, it was found total numbers of bottles in all 5 packets is 1000.
Yes.
There has to be some mention that contents of the bottle.
No, lordship, regarding 100 bottles where it is mentioned, lordship. Each bottle contains 100 grams, lordship.
That is apart from oral submission. Where is the?
No, lordship, it is fake, lordship. It is contains 100 grams. And lordship,
That is their defense.
no, lordship, even their defense, lordship, whether it is like sustain. 100 bottle is admitted, lordship.
Yes.
So they have not stated that it is contain less.
Now, how much is the content?
It is 100 ml is the content of one bottle.
No, where is, somewhere it has to be mentioned in the Caesar list.
In the bottle itself, it is mentioned, lordship. Although in so many words, it is not stated in complaint, lordship. Lordship, please to see the FSL report, lordship, page 49. If it is the case of the petitioner that bottle contains only the narcotic substance, but they have not made such type of statement, their content, nothing has been mentioned. But regarding content, lordship, it is mentioned that some contents have been stated. And it is, lordship, in the record that each bottle contains 100 grams. 1000 bottle is admitted. They are not also denying.
No, I just want that. Where it is mentioned that.
Lordship, please to see result of the examination. Exhibit so and so gave result positive test of codeine present phosphate. Accountant codeine phosphate were found to be 169 mg. Then natural substance is also there. 169 is admitted. And regarding
How much nature, how much other
is
neutral?
it's contains 100 grams.
No, that is their defense. And that otherwise also somewhere, how the court will know that?
No, lordship, it is presumed that lordship,
No.
otherwise I'll produce the samples before your lordship today itself in the evening. At 3:30, lordship may fix. I'll ask the IU to complete the samples. Lordship may examine whether it is.
That is the only option.
Whatever he has got, assuming, my lord, not admitting at this moment, my lord, for the purpose of instant case, my lord. Suppose he has got, my lord, 1,100 milligram whatsoever, but it has to be mentioned somewhere, my lord. Court cannot go presumption, my lord. It has to be on record that this weight 1,000 bottle contains suppose 5 kg or 10 kg, whatsoever it is. It has to be there, my
My have also, my lordship, when content is admitted.
No, they are not admitting.
No, they are not admitting, but on record, lordship, 1,000 bottle is 1,000 bottle
FSL
is admitted.
quantity, my lord, there is no natural or neutral quantity.
Nowhere it is mentioned that.
No, it is, lordship, may please to see whether natural content is, not, natural content is not mentioned, but narcotic content is mentioned here.
Mentioned.
It is mentioned.
169 codeine phosphate is found.
Found.
Yes.
Mg is found. In what was the total content of the, somewhere it has to be mentioned in the entire record.
Seriously, so whatever I have studied, my lord, I did not get it.
Now, whether, lordship, whether it can be a ground for causing.
No, my lord, only section, my lord, 2B or 2C.
No,
That is my case.
Lordship, it
I
is
have not come
admitted.
for causing for any proceeding, nor I have come for staying of the operation of the thing. Only, my lord, the charge has to be 2B or 2C. That your lordship will examine. So far available on the record does not disclose, my lord.
Lordship,
What is the weight?
Lordship, one thing is admitted, 1,000 bottle is admitted, lord.
1,000 bottle may be empty also, my lord. Without document, my lord, how can presume against me?
In this case,
It is
you
not
are-
the case of the petitioner that nothing, the bottle was empty. Let them come with this statement.
What,
Lordship, I'll give
which
reply.
order you are impugning?
I am impugning, my lord, only framing charge, annexer page 50, annexer 6. Only that much. Secondly, that so and so NDPS Act 21C.
Now, if it is the case of the petitioner that other bottles were empty, let them come.
My lord, it is the burden lies on the prosecution, my lord, to prove that I got recovered from you 1,000 quintal or gram, whatsoever it is. It is not me, my lord. Just before, my lord, in Bihar case, my lord, therefore yesterday judgment was there, my lord, where the police asked the accused to prove that you are innocent. That cannot be the law, my lord. That lordship may be aware, my lord. Day before yesterday, my lord, most probably Friday or Thursday, apex courts part the judgment. Always onus lies, burden of proof lies on them, my lord, to cast upon me that this is the.
No, can we dispose it of finally? This finally.
It can be disposed of, Lordship, because Lordship may please to come to page 18, your seizure list.
Yes.
Item 1, fancy deal cup syrup, packed 5 packets, so and so, so and so. Quantity bottles, 1,000 bottles.
There is
Now
nowhere
it is
mentioned.
1,000 bottles
No,
of
no,
1 liter each, 100 millimeter each, 10
Nothing,
millimeter each. What is the content?
Lordship, then I can place before a Lordship the samples which are in the custody of the.
My lord, if the sample will overrule, my lord, the provision of law.
To-
Whatever
to
document
det-
has to be there, my lord.
To determine what is the content of the Lordship, it is mentioned here other contents.
Court
Lordship
is
may-
not, my lord, at this stage is not examining authority, my lord. My learned friend, my lord, should have known all these things.
I know very
Bringing
well.
Sample as if like a, my lord, a criminal case has been initiated. This is the weapons used in criminal offense. Can it be like this, my lord? It cannot be.
Lordship may,
Document has to be there.
Lordship may please to come to page 20. Arey bhai, either you submit or let me submit.
No, I'm not submitting.
No, no.
I'm not submitting. You
I'm
submit.
placing Lordship, what is in the record, I cannot change anything. Lordship may come to page 20, third paragraph. As per the label, each bottle contains codeine phosphate 10 mg,
Here also they don't
then
mention.
4 mg, then 18 mg. Date of
Hotel. Hotel can dispute.
manufacturing date 18, expiry date 20. Manufactured by Arab so and so.
You go through the record. Anywhere if you can show in the entire record, in CD, in case diary, in any document that it is 100 ml. I am fixing it tomorrow.
Watch.
Look.
My lord, only one
have-
thing, my lord, 14 or 15, there is a judgment, my lord. Disposal, final judgment from mobile I have seen. So at least some order, my lord. Till 1 week or 7 days, no further order has to be passed. My lord. Till, my lord, only
No.
2 days,
I'm
3 days,
No,
subject to my learners. The moment judgment is passed, everything will go.
And in this High Court later on holds that charge was defective, then judgment will automatically go.
Yeah, they will get benefit in appeal lot.
My lord, the judgment is again, my lord, I am poor fellow, my lord, again it will be complicity of the case. Only 1 day or 2 days, my lord. Till, my lord, 14, no order has to be passed, only that much.
Tomorrow lordship taking up the matter tomorrow.
We'll take it up tomorrow.
If it does not reach also, my lord, or lordship fix them like this, my lord, subject to your lordship's condition. Lordship fix the matter tomorrow at 2 o'clock. So that, my lord, no adjournment, nothing. will
What
be-
you have to show you on Mr. Kyle,
No.
you have to show that
Each bottle contains 100.
100
Yes,
ml. The
the documented.
100 ml or whatsoever the content is of the bottle is there. We don't know whether it is 100 ml or not.
Lordship,
It is only your submission. So somewhere it has to be shown that
the correct
Yes.
lordship. I'll check up the record because record is come.
anywhere in record, anywhere in the case diary, any document,
Lordship,
Any
It
exhibit or
shows.
Caesar list, anything.
lordship.
even if because the photographs of the samples were
Taken.
taken.
Yes, lord.
If you can show from the photograph that the
Yes,
Has to be
contents are
exhibited, my lord. Their photograph will not do, my lord. It has to be exhibited.
Because
No,
it was
no,
certified
that will
by
do
the.
at this stage.
It
It will
was,
do.
lordship, that was certified by the learned CGM also.
No, I am just giving you a hint
No,
that
lordship.
it may also do, but somewhere.
My
some
lord, I
record-
honestly made submission, my lord. If they can show a single document. That it
Okay,
is a
let them
content.
show, let them show.
Lordship,
Yes.
I'll.
How Mr. J.
I bought here.
J.I. Bordmia, learned counsel for the petition, also had Mr. S.C.K.R., learned standing counsel NCB, who prays for some more time, who prays for some accommodation to bring to go through the records and answer some specific queries which was raised by this court. The prayer is allowed.
2 o'clock tomorrow, my lord. It will be fixed item, my lord, 2 o'clock. In other matter also, my lord, can be done.
DBS.
DB9 is. Absolutely.
Lordship, if required, my learned friend can mention this matter.
No, my lord, mention, I will be having other cases, my lord, I got.
No, I
already-
don't know the roster.
No, my lord,
Or-
if it is at 2 o'clock, if it does not, my lord, we will make mention appropriate times.
Okay.
Lordship fix the matter at 2 o'clock. So
Is it
that, my
okay?
lord, both of us we can come.
Let this matter be listed again on 13 February 2023 at 2 o'clock.
Lordship,
Lordship.
obligement.
Lordship, this matter may be taken up after some time, Shiloh. My senior is on legs. Okay.
Item number 17 and 18.
Yeah, please, your lordships. On last occasion, what happened, lordship? Just to confirm whether appellant that is in appeal number 42, yes. To get the authentication whether he is alive or not. But it is mistakenly written in this order, lordship, that so far the appellant number of this case 35 is concerned. That is wrongly given here, lordship. We prayed for get the information for second appellate Jyotish Borwa, lordship, in second appeal. In criminal appeal 42, lordship. Item 18, yes. Yes.
Why this submission was made? Has he expired?
Oh, just to ascertain that, Lordship,
No, no, why this necessity was felt?
because my appeal, second appeal number, next one, no?
42.
30, 42. Or
There are
35.
two appeals, 35 and 42.
Yes, yes.
Your submission is that on last occasion, in appeal number 35, it is wrongly mentioned
Yes, Lordship, that is
instead of the appellant of appeal number 42.
Lordship.
So my query is why this question was raised that the appellant is alive on.
The counsel for other side, Lordship, the appellant of 42, no? 42. So they have not gathered any information about their appellant, Lordship. So I got an information from my client that say he is already expired.
Okay.
So just to ascertain that, it is better to get the information from the authority, airport authority, where he was working last, Lordship. Guwahati Airport Authority, Guwahati, Lordship.
They are on bail.
Huh? Yes, they are on bail.
Both the appellants were on bail.
Bail, Lordship. They are on bail.
Who is appearing for Jyotish Barua? Appellant number.
K. Kamal Agarwal, Lordship, senior advocate. He is unwell today, Lordship. She is representing.
Okay. Now what is to be done?
Lordship, the same thing has to be done, Lordship, which the wrongly that order has come, no? Huh?
Lordship, may call for a fresh report.
Fresh report,
In
Lordship,
respect of
yes.
Jyotish Barua, that is in criminal appeal 42 of
42.
2012.
From whom?
From the concerned authority that's.
Airport Authority of India, Lordship, Barjhar,
Through concerned OC, Lordship.
Kahikuchi, address is with me, Lordship.
Heard Mr. S. Das Gupta,
Lordship.
Learned Counsel for the appellant in criminal appeal number 35/2012. Also heard Miss P. Neog, Learned Counsel appearing for appellant in criminal appeal number 42/2012. Also heard Miss S. H. Bora, Learned Additional Public Prosecutor. It is submitted by Mr. S. Das Gupta, Learned Counsel for the appellant, that in order dated that on last occasion, this court was apprised that the appellant in criminal appeal number 35/2012 has come to know that appellant of criminal appeal number 42/12, namely Jyotish Barua, has expired.
Lordship.
And a request was made to ascertain and to call for a report from the concerned authorities as to whether the appellant Jyotish Barua is alive or not. However, it is submitted by Learned Counsel for the appellant that due to mistakenly in order dated 8/8/2023, a report was called for in connection with Shri Kanak Sarkar, who is in fact the appellant in criminal appeal number 3035 and 35/2012 instead of Shri Jyotish Barua. Stop. Same is required to be rectified. Let the registry again, let the registry call for a report from the officer in charge of Ajara Police Station as to whether the appellant in criminal appeal number 35/2012, namely Shri Jyotish Barua, son of late Bipin Barua, resident of Airport Authority, New Colony, Kahikuchi, Borjhar, is alive or not.
Kahikuchi, Borjhar Kahikuchi, Lordship.
Borjhar Kahikuchi is alive or not. the report should reach this court
Case number
through the registry within
Yes,
2 weeks from the date of this order. Let this case be listed again after receipt of the report from the
case number Lahore.
officer in charge of
Lahore.
Ajara Police Station.
Lahore. Lordship, it is Lahore case number.
But in the memo of appeal, the address is given Ajara.
That is because at that time, Lordship, at the relevant period of time, he was working there and residing there in Airport Authority Colony, Lordship.
So from where we will call for? Now,
There will be two places like here.
one more address is there.
No address, Lordship. From Airport Authority, it can be confirmed whether he is alive or not. Lordship. They are the authority under whom he was working.
No, how they will know if he has already retired or he is not the resident of Ajara. His address in the memo of appeal is given at Ajara.
Ajara, Lordship. It is there.
I think that will be.
That will do, Lordship.
Let us see what report comes.
Lordship.
It will clarify if he is
Lordship.
not there in Ajara. Let this matter be listed after 4 weeks.
Address of properly.
A2 অফিসত কাম কৰিছিলে এয়াৰপোৰ্ট অথৰিটি বৰঝাৰ কাহিকুচি গুৱাহাটী 15
PS হ'ব তেওঁ দি দিলে
PS টো হেৰি হ'ব বৰঝাৰ PS কি হয়
মই নাজানিম দেই এইটো
বৰঝাৰ PS
তেখেতক কৈছো তুমি দি দিয়া না এইটো ভালকে
বৰঝাৰ PS টো কি
Item 19.
Nagore case to yes, please.
May I please your lordship? Okay,
Yes,
as per the office note dated 27/9/2012, LCR has been received, lordship. So the matter is already admitted as per the order dated 8/8/2012. And LCR was called for, it has also come. So let the matter be listed for final hearing, lordship.
Heard Mr. V. A. Chaudhary, learned counsel for the petitioner. Also heard Miss S. H. Bora, learned additional public prosecutor. Where is the office note? Yes,
Office note dated? Office note dated 27/9/2012.
office two.
After the orders, lordship. After the order features.
Then why it has come in orders column?
It was called for, lordship, but subsequently no order was passed that it has been
On
received.
perusal of the office note dated 27/9/2012, it appears that the records of CR case number, it appears that the NCR has been received by the registry. Hence, NCR has been received by registry. Learned counsel for the parties have submitted that this case is ready for hearing.
Lordship.
And accordingly, this may be listed for hearing.
Lordship.
Stop. Let this case be listed for hearing when?
After 4 weeks, lordship.
After 4 weeks.
There is an interim that may kindly.
Interim order shall continue.
Highly obliged.
See this, I trademark one page in the LCR that contains, and page 49 also it contains next.
100 ml is there.
Yeah, it is there.
That will do.
Page 49 of the.
But then tomorrow at 2, we may not be able to take it
Lots
up.
of anytime.
Before 2.
Lots
What is it? What is it?
Before 2 or after rising of the DB.
Before 2 weeks, I will come back.
Okay.
In the meantime, I have flagged what the
Kartidi.
lots.
Full details to member. Even.
I'm taking a short break.
Lord.
Morning.
Yes, I have received your written.
Milord, we have also sent the copy to the government advocate Nagaland, Milord, by mail.
Only one query I have,
My lord.
that is section 14 of the Nagaland, this Petroleum Act
My lord.
has vested the power of assessment,
My
reassessment
lord.
on
My
the
lord.
commissioner.
On the assist Milord, on the supreme taxes.
No, it
The
says
the
on commissioner.
Well, the power is with the commissioner, but it has been delegated to the supreme taxes.
Yes, that is my query actually. The query is section 45 of the act says that by notification, this power can be delegated.
My lord, it has been delegated because, my lord, against the order passed under section 14, the appeal lies to the assistant commissioner and the revision lies to the commissioner of taxes. So the power has been delegated to the supreme taxes, my lord.
Yes, that argument I have understood. You have made that argument on that line also.
My lord.
My pointed query is there any notification issued under section 45 of the act?
Well, it must be
whereby this
because
power has been delegated.
well, it must be.
I
I have
don't
to
want that notification. If both parties agree, government side also agrees that there is in fact a notification regarding delegation, because assessment is done by superintendent of taxes, not by the commissioner.
No, my lord.
But the act says, the act gives the power to commissioner.
My lord, in fact, under the act, all powers have been given to the commissioner only.
Yes.
And then the commissioner has delegated the powers to the various authorities. Your lordship is correct, my lord. If I'll try my best, my lord, to find out the notification, it has to be there, my lord.
Please, for a while, come to section 45 of the act.
My lord. My lord.
Section 45 says that commissioner may, by notification in official gazette, delegate any of his powers
My lord.
to officials subordinate to him.
My lord.
So my query is whether
If
in
the
fact any such notification has been
I will
issued.
just try to find out, but in the timing, my lord, lordship see page 42 of the petition, my lord.
42.
My lord.
Yes.
First of all, your lordship may see, my lord, page 29, first of all. Page 29, my lord.
Yes.
The assessment order original was passed by the supreme taxes. You also find the bottom.
Yes.
Thereafter, you also may further see, my lord, page 42. The last paragraph, my lord. After passing of the order, the London Supreme Taxes Dimapur is hereby directed to issue demand notices for so-and-so working days. So the demand notices and assessment order are to be done by the Supreme Taxes. Thereafter, page 43, you also may see. The demand notice was issued by the Supreme Taxes.
Okay. But
No, you lost it, correct, my lord. I will try to find out whether it is available on the net or not. I will
Okay.
try to find out, my lord, to the best of my ability, my lord.
heard Mr. Dr. A. Saraf, learned senior counsel for the petitioner, assisted by Mr. P. Barwa, also Also heard, assisted by Mr. P. Burwa, learned counsel for the petitioner. Also heard Mr. Moa Imchen, learned senior government counsel for the state respondents. Both the parties have submitted their written gist of argument. Let this case be listed for delivery of judgment on Monday, Kingston. On 19th February 2024.
Well, you'll also see further, we'll see page 39 also, Miller.
39 of the writ petition.
Of the petition, Miller. The third paragraph, Miller. It is observed that the assessment order passed by the London Supreme Taxes for the so and so are erroneous insofar as it is prejudiced to interest of revenue. And you also got in, Miller.
Yes, in fact, in this case, assessment orders are passed by
Supreme Taxes. So as I'm just showing that the assessment orders are to be passed by the, and you'll also further see page 41.
Yes.
Therefore, considering the facts and circumstances of the case and in the interest of the so and so, the order dated so passed by the Supreme Taxes for the so and so is set aside. My lord, the assessment order which is passed, it is revised by the same authority, escapement, because the assessment and reassessment powers are with the assessing authority only. The assessment, reassessment is nothing but assessment power, my lord.
Okay, still if it is possible.
Well, I will try my best. No, today itself, I will try to search out from the
45 of the act.
My lord, because it is a Nagaland Vet Act, it has already been repealed. So whether it is Nagaland website, it is there or not. But I will try my best, my lord, to find out.
Okay.
Your Lordship.
Yes.
Your Lordship. Yes, Your Lordship. And we are not to say one word.
Yes.
Your Lordship, 21(1) is very clear. So that is why I'm saying that the alternative remedy was not.
No, that you have argued already, that your submission is that provision for appeal lies.
Yes, if he has a petition is required, then he could have.
But
we have replied to it.
On that, there is a reply.
That's why I'm saying.
Okay, I will decide.
The petition is not maintainable because alternative remedy is there. It's provided, it's very clear.
My lord, I may submit only one thing, my lord. If you also permit me, my lord.
Yes.
My lord, the judgment which is referred in the court as Sarali, my lord, that was also against the Shiomoto revision order.
And your lordship, a petitioner has not challenged that provision.
There is no question of challenging the provision because I am not challenging the provision. My lord, the Supreme Court in that case, Kota Sarali, my lord, held that in the case of the revision itself, my lord.
Which case?
The Godrej Sarali, my lord, I referred to in the written submission.
Yes, where the alternative remedy has been discussed.
And it was a case of Shiomoto revision only, my lord. Okay. That case was also Shiomoto revision. And the Supreme Court said that when the Shiomoto revision order is challenged on the ground of without jurisdiction, then the question of alternative remedy is not there. That is the Godrej Sarali. I have given the paragraph number also. My lord.
Yes, I have noted. Okay.
My lord. And today itself, I will try to find out, my lord. And if possible, my lord, by tomorrow, my lord, I will furnish the copy of the to the best of my ability, my lord.
On 19 February, I will deliver.
Lordship, I beg Lordship indulgence regarding item 32, Lordship. That item on all Lordship are laid in court number 15, Lordship.
Item number
32, Lordship. I was non-apparent. My appearance can be shown, Lordship. We have already taken step.
Okay. In item number 32, I show the appearance of Mr. B. Chaudhary.
I have already taken step, Lordship. I live.
Item 47.
Mr. Chaudhary, is it 32 or 34?
32 Lordship. 32 Lordship. I live. This is complete in this case.
Service is complete.
Other side is operating.
It will go for hearing.
It may be fixed for hearing also.
Heard Mr.
And A Dhanuka Lordship.
A. Dhanuka, learned.
Proxy counsel, appearing on behalf of Mr. B Pusila.
This is item number
37.
appearing on behalf of Mr. P. B. Pushila, learned counsel for the petitioner. Also heard Miss
A Lala Lordship.
A. Lala, learned counsel for the respondent number 2, as well as Miss N. Das, learned additional public prosecutor. The service is complete. Let this case be listed for hearing in its usual course.
In this case, service is, steps is not completed.
Anything?
Lordship, in item 37, there is a stay order.
There
So
was date order.
date may be fixed, Lordship.
Okay, then.
He is enjoying stay order.
Then in earlier order.
Actually, Lordship, you should come for admission hearing. Rule is yet to be issued, Lordship.
Okay, let this case in item number 37. Let this case be listed for admission hearing on, give a date after.
So the interim order may continue. Lordship.
12/3/2024. The interim order shall continue till next day. Yes,
2 weeks time may be granted for taking steps, Lordship. I have not taken steps.
heard Mr.
M. Mondol.
M. Mondal, learned counsel for the petitioner. Learned counsel for the applicant who prays for some more time for taking steps for issuance of notice on the respondent. The prayer is allowed. The petitioner, the applicant shall take steps for issuance of notice on the respondent number 2 by registered post with AD. Sorry. Within 3 days from the date of this order, returnable after 4 weeks. Let this matter be listed after 4 weeks.
Okay. 39 is an appeal hearing. Miss Bijita Sharma, she informed me she is in court number 1 and she is in a session of a matter. So she has prayed for another date, 15th or any date. 15th is
Mr. 15 maybe
coming Thursday. Oh, acha, day after tomorrow.
day after tomorrow,
Any date, Lordship, at your Lordship's convenience.
next week.
1920. I've seen the matter.
Sorry. Heard Miss Learned amicus curiae is not found on call. Learned additional public prosecutor has submitted that the amicus curiae is on legs in some other court,
Court number 1, she
in
is.
court number 1. And stop. Let-
Oh, she is here, she is here. No, it's up to you, whatever. Go, oh, she will do this.
You are ready?
There is a matter fixed up to it, court number 1.
Okay, then let us hear.
No, no, I've seen. तुम्हारा करना है और ठीक बहुत किसी का ही पहले से
There are two appellants, Lordship, husband and wife. Ejaha Lordship pays seven of the paper book Lordship. May I read the Ejaha Lordship?
Yes.
Lordship. Here, two persons, husband and wife, they are the appellant Lordship, and they were convicted under section 304 part 2 Lordship, part 1 Lordship. RI for 7 years with fine of rupees 5,000, and there is also default clause Lordship. The deceased is 70 years old. Incident took place on 10 p.m. of 17 to 2018, and the person died on the next date on 18 to 2018.
Who is the deceased?
Deceased is Kesaram Musahari, 70 years old person.
Yes.
Ezahar was lost after his death Lordship by the son of the deceased. Judgment was of 7/5/19, and almost 5 years they are behind the bar Lordship from the date of judgment. Here Lordship, I am reading the Ezahar Lordship, page 7 of the paper book. সন্মানপূৰ্বক বিনীত নিবেদন এই যে যোৱা ইংৰাজী 17/2/2018 তাৰিখে ৰাতি 10 মান বজাত ওপৰত উল্লেখ কৰা অপৰপক্ষৰ লগত মোৰ পিতৃ শ্ৰী কেশৰাম মুছাহাৰীৰ লগত তৰ্কাতৰ্কি হয় আৰু তেওঁলোকে মোৰ পিতৃক মাৰপিট কৰি গুৰুতৰভাৱে জখম কৰাত আজি ইংৰাজী 18/2/2018 তাৰিখে মোৰ পিতৃৰ মৃত্যু হয়। তাৰ অপৰপক্ষৰ মাৰপিটৰ বাবে মোৰ পিতৃৰ মৃত্যু হৈছে। আমি পৰিয়ালৰ লোকে পিতৃৰ শুশ্ৰূষাত লাগি থকাৰ বাবে এজাহাৰ দিয়াত পলম হ'ল। তোমাৰ ইংলিছ আছে? মোৰ নাই, অসমীয়া আছে। সেইখিনি আছে চাগে?
I have two paper books. One paper book consists of Assamese version and the other English.
I have only the Assamese one in the Ezahar. Others are in English. Evidences are in English.
That's it.
So Lordship, here 10 PWs were examined Lordship, and 330 statement of the persons are of total denial, although no DW were examined. So I'm reading the PW1. PW1 is one Nirmal Sorgiari. I know both the accused person present in the dock, namely Lakshmi and Anil Busumotari. They are husband and wife. The incident took place on 17 to 2018. Deceased Kesaram Musahari was my father-in-law. At about 11 p.m., deceased along with his wife Jugeshwari Musahari went to Smosan to offer puja. After returning from puja, an altercation took place in the house of one Subhas Boro in between the deceased and the accused person. Thereafter, deceased came to his house along with his wife. On the said night, both the accused came to the house of the deceased and again took quarrel. Lordship, here first time it was in the house of Subhas Boro. On the said night, both the accused came to the house of the deceased and again took quarrel. Then Lakshmi and Anil assaulted deceased with a bamboo lathi. On hearing halla, I went to the house of the deceased and saw deceased was found bending, and near the deceased both the accused were standing. I have also seen one lathi lying at the place of occurrence. In the next day at about 2 p.m. he was died. I have saw injury on the left side chest of the deceased. Next day, wife of the deceased also informed me about the incident. During investigation, police came and taken the dead body to the hospital for postmortem examination. Police also conducted inquest upon the dead body. Plus, if he stated that he had seen, and the very next line he stated that next day, wife of the deceased also informed me about the incident. So, in one hand, he was stated that he had seen the occurrence, and another hand, he said that he came to learn from the wife of the deceased. Cross. I have not seen who assaulted the deceased and how the occurrence took place. I do not know the content of the exhibit 1. Police recorded my statement on the next day of the incident at about 2:30 p.m. at Misamari police station. It is not a fact that the incident took place 17 to 2018. Deceased Kesaram Musahari was my father-in-law. At about 11 p.m., deceased along with his wife Jugeshwari Musahari went to Smosan to offer puja. After returning from puja, an altercation took place in the house of one Subhas Boru in between the deceased and the accused person. Thereafter, deceased came to his house along with his wife. On the said night, both the accused came to the house of the deceased and again took quarrel. Then Lakshmi and Anil assaulted deceased with a bamboo lathi. On hearing halla, I went to the house of the deceased and saw deceased was found bending near the deceased. Both the accused were standing. I have also seen one lathi lying at the place of occurrence. In the next day at about 2 p.m., he was died. I have saw injury on the left side chest of the deceased. Next day, wife of the deceased also informed me about the incident. And here in cross, he has stated that it is not a fact. So whatever he has stated in his examination in chief, he stated this is not a fact. My father-in-law Kesaram Musahari used to drink liquor, and on the 11th day of the incident, the deceased consumed liquor. The puja took place at the smosan. It is not a fact that on the day of incident, deceased consuming excessive liquor, he became intoxicated and fell down several times. Then Subhas Boru and Someshwar Boru took him to his house, and the deceased died due to fall here and there. Accused house is situated at a difference of two houses, about 150 feet from the house of the deceased. It is not a fact that on the day of incident, Anil was slept in his own house. It is not a fact that Anil and his wife arrived at the place of occurrence after taking deceased to his house by Subhas Boru and Someshwar Boru. Police did not seize the said bamboo lathi from the place of occurrence. It is not a fact that I have not seen any bamboo lathi at the place of occurrence. It is not a fact that as there is no lathi at the place of occurrence, so police did not seize the same. So this is his cross-examination logic. It is fact that I have made statement before the police that as the injury was not so serious, so we did not took him to the hospital. PW2 is Onima Sorgiari. I know she is the wife of PW1. I know both the accused person present in the dock, namely Lakshmi and Anil. They are husband and wife. The incident took place on 17/2/2018. Deceased Kesaram Musahari was my father. At the night after having one dinner, we have been to bed to sleep. During that time, we heard a halla in the campus of Someshwar, who is the son-in-law of the accused person. In the said night, Shiva Boru came to our house, woke up us and informed about the incident. We immediately rushed to the place of occurrence and took my father to his own house by Someshwar and Shiva Boru. When my father regained his sense, he told us that accused Anil and Lakshmi assaulted him. We advised them to take our father to doctor. In the next day, my father died. During investigation, police came and taken the dead body of my father to the hospital for postmortem examination. Due to assault of the accused person, my father's chest bone was fractured. Cross. We reside in the same campus where my father and mother were resided. I, along with my husband, woke up and rushed to the place of occurrence. My father was taken from the boundary of Someshwar. My deceased father told us that accused person came to the house of the deceased and took him from the bed to his boundary of Someshwar, where my father was assaulted by the accused person. As my father told about the incident before us, so we came to know about the incident. We kept our father at home as because we have not seen any injury at first. We do not have any money, so in spite of our willingness, we do not took our father to the hospital for treatment immediately. It is not a fact that I have deposed falsely. When my father regained sense and informed us that accused Lakshmi and Anil assaulted him, during that time many people were present there. It is not a fact that when my father regained sense and informed us that accused Lakshmi and Anil assaulted him. My father Kesaram Musahari used to drink liquor, and on the relevant day of the incident, the deceased consumed liquor in the puja. It is not a fact that on the day of incident, my father consuming excessive liquor and he became intoxicated and fell down several times. Then Shiva Boru and Someshwar Boru took him to his house, and deceased died due to fall here and there and sustain injury. It is not a fact that accused person did not assault my father. It is not a fact that I have not stated to police that when my father regained his sense, he told us that accused Anil and Lakshmi assaulted him. It is not a fact that I have not stated to police that we advised them to take our father to doctor. My father regained his sense at about 3 a.m. It is not a fact that my father regained his senses at about 3 a.m. It is not a fact that I have deposed falsely. This is PW3 is the doctor, and according to him, the injuries are antemortem caused by blunt weapon. In my opinion, the death was due to shock and hemorrhage as a result of injury sustained. Injury described in my report is sufficient to cause the death of a person. So, this type of injuries may be caused by fallen on hard substance. So there is a possibility that he may have fall down logic. PW4 is Sibaboro. I know both the accused person present in the dock, namely Lakshmi and Anil Bosumatari, they are husband and wife. Incident took place on so-and-so at a night at about 10:30 p.m. I knew the deceased Kesaram Musahari. After hearing Halla, I came to the place of occurrence and saw Kesaram Musahari in the boundary of Someswar Boro. I saw accused person standing near Kesaram Musahari. Then I, along with Someswar Boro, took the victim Kesaram Musahari inside the room. During the time, Kesaram told me that he has been assaulted. As we do not notice any injury of the victim as serious, so I could not take the victim to the hospital. Next day, Kesaram died. Police came and taken the dead body to the hospital for postmortem examination. Police recorded my statement. It is not a fact that I have not stated to police that I saw Kesaram Musahari in the boundary of Someswar Boro. I saw accused person standing near Kesaram Musahari. During the time, Kesaram told me that he has been assaulted. So these are improvement, Lordship. These none had said about this at the time before police, Lordship. The distance between the place of occurrence and my house is about 150 meters. That is the distance between from this court to the main gate of our court campus. When I reached at the place of occurrence, I have seen only two accused persons. I have heard the sound of dhap-dhup at the place of occurrence when I just reached the place of occurrence. I have not seen the incident. On that day, there was a puja in our village, but I have not attended the said puja. I heard that Kesaram attended the said puja and act as a priest in the said puja. In the puja, liquor was offered. Kesaram was my uncle. It is not a fact that this is being uncle, therefore I have deposed falsely as stated above. It is not a fact that I have arrived at the place of occurrence only after arrival of other person. PW5 is Junu Musahari. He is the informant. I know the accused person present in the dock, namely Lakshmi and Anil. They are our neighbor. This was my father. The incident took place at so-and-so night. At the time of incident, I was at Tezpur. Next day of the incident, my elder sister Onima Sorgiari called me to my parental house at Bharpheri, stating that Lakshmi and Anil assaulted our father and so he was in serious condition. I meet my father in injured condition and my father told me that Lakshmi and Anil assaulted him in the boundary of Someswar Boro. My father also told me that he sustained pain in his chest, head and stomach. Then we asked accused person to our house to see my father and to take him to hospital, but they did not come. Then I went to the police station to inform the matter. In the meantime, my father was died. Police recorded my statement. It is not a fact that I have not stated to police that next day of the incident, my elder sister Onima Sorgiari called me to my parental house, so-and-so, Lordship. He denied that he has stated those to police. At about 9 a.m., I have received the information of my elder sister. It is not a fact that my elder sister did not inform me about the incident. At about 11 a.m., I reached the place of occurrence along with my baby went to the place of occurrence. According to me, nobody informed about the incident to police except me. At about 2 p.m., I lost the Ejahar. Before that, I informed about the incident to police Bharveli. After informing the matter to police, I have gone to my home. Thereafter, I have filed the Ejahar. Police visited the place of occurrence after receipt of Ejahar. It is not a fact that in the Ejahar as well as in my verbal information to police, I have not mentioned that my father told me that accused Lakshmi and Anil assaulted him. When I reached my parental house, I met two women. One is the wife of Numal and other is the wife of Petela and one Sri Boru. My father used to consume liquor at night. It is not a fact that on the night of incident, my father fell down on the chips and stone road after consuming liquor excessively. House of Someswar is situated near our house. House of the accused person is situated next to the house of Adivasi next to Someswar house. PW6 is Jugeshwari Musahari. She is the wife of the deceased, Lordship. I know both the accused person present in the dock, namely Lakshmi and Anil. They are our neighbor. Deceased was my husband. Incident took place about 5 months ago. 5 months ago at night. After having dinner, I along with my husband were sleeping. My husband used to sleep in the front side room of our house. At about 3 p.m., my husband asked a glass of water to drink. During that time, he told me that accused person Lakshmi and Anil Bosumatari assaulted him by means of a bottom after calling him out. Next day of the incident at about 10 a.m., my husband died. So her evidence is totally contradictory, Lordship. Neither other evidences is that he went in the smasan to perform a puja, and thereafter he returned and the incident took place in another person's house. And here her evidence is that they were sleeping, then only her husband told her, and he died at about 10 a.m. Cross. After the death of my husband at about 10 a.m., as there were no other family member in our house, so I have not informed the matter to police station immediately. I have informed to my nephew Numal Sorgiari, and he informed the matter to police station. PW once stated that only he had informed, but mother's evidence is that another person had informed. Police recorded my statement. It is not a fact that I have not stated to police that after having dinner, I along with my husband were sleeping. My husband used to sleep in the front side room of our house. At night at about 3 p.m., my husband asked a glass of water to drink. During that time, he told me that accused person Lakshmi and Anil Bosumatari assaulted him by means of a bottom after calling him out. Next day of the incident, at about 10 a.m., my husband died. After having dinner, I went to sleep and woke up in the next day morning. My husband, after attending puja, came to house after consuming liquor and slept in the bed. It is not a fact that on the night of incident, my husband fell down on the cheap and stone road after consuming liquor excessively. It is not a fact that accused person did not assault my husband. Accused person are resided in a separate house near the house of Kerkon, who is my brother-in-law. Kerkon is still alive. Kerkon live with his family. So this is her evidence. PW7 is the person in whose house according to the prosecution, the incident took place. I know both the accused person present in the dock, namely Lakshmi Maya Bosumatari and Anil Bosumatari. They are our neighbor. I know that this is Kesaram Musahari. Incident took place in the month of March at night. On that day, we offered puja at our house. After having prasad, all guests went their own house. This is Kesaram also attended the puja. He also having prasad and went out to his house. At about 9:30 p.m., Halla took place in the house of Kesaram, and then I rushed to the house of Kesaram. Then I saw both the accused person in the house of Kesaram. Accused persons took quarrel with deceased. Next day, Kesaram died in his house. Police recorded my statement. At this stage, the witness is declared as hostile. Cross-examination by prosecution. It is not a fact that I have stated before the police that altercation all stated then about some boundary dispute between Kesaram Boro and Someswar Boro, son-in-law of Anil and Lakshmi Maya Bosumatari. Later on the same night, they had an altercation and Anil and his wife assaulted Kesaram, to which he sustained injuries and died today. It is not a fact that I have deposed falsely today to save the accused person. Cross by defense. Kesaram is my maternal uncle but not own. We just call him as Mama. It is not a fact that Kesaram is my own maternal uncle. Kesaram resides in a, so this is the important line is Lordship. Paragraph 4 or 5. Kesaram performed as a priest in the puja. In the puja, Kesaram used to drink liquor. At about 9:30 p.m. after consuming liquor, Kesaram left our house. After left Kesaram from our house, I do not know where he actually went. Altercation took place in the house of Kesaram. There is no any altercation took place in our house. I have not seen any altercation in the house of Kesaram. Anil Bosumatari used to live in his own house with his family. I cannot say on that day whether Anil Bosumatari was live in his own house or not. I heard Halla in the house of Kesaram. Then re-examination. Then again, Lordship, this is PW8. PW8, Someswar Boro. I know the informant June Musahari. I know the accused Anil and his wife. They are my father-in-law and mother-in-law respectively. Incident took place in last February 2018 at night. At a relevant time, I was sleeping. When I woke up, responding Nesa's call, I heard some halla near the house of Kesaram Boro. I rushed to the spot and saw Kesaram was found kneel down and bent towards the bamboo fencing situated at the side of the road. I heard from local public that Lakshmi Maya killed Kesaram by means of stick lathi. Kesaram was sustained injury and expressed his pain, but he was not brought to the hospital immediately, but treatment was done at his home. At about 3 p.m., Kesaram died. Then police came and dead body was taken to the hospital for postmortem. Cross. I have not seen any incident personally. When I have seen Kesaram in kneel down and bending his head towards the bamboo fencing, it was after 10 p.m. During that time, Kesaram was drunk. I have not seen any other person. After my arrival, Shiba Boru arrived and myself with Shiba Boru took him to his house. During that time, he did not state anything to us. I cannot say specifically from whom I heard that Lakshmi Maya assaulted the victim. I do not see what type of treatment provided by the doctor. On that day, there was a puja in the house of Subhas Boru where priest was Kesaram. We used liquor during puja. My house is situated at a difference of 1 bigha land from the house of Kesaram. I do not know how Kesaram died. I have not seen any injury. PW9 is the IO lordship. On 18 to 18, I was posted on so-and-so lordship. Before registration of the Ejahar, complainant Junu Musahari appeared before me in the police station and informed about the incident. Accordingly, I made a GD entry number so-and-so. I have also recorded the statement of the witness. I also informed the circle officer Thelamara for conducting inquest, and after completion of inquest, I sent the dead body for post-mortem examination to Kokrajhar Civil Hospital. I also apprehended the accused, and after interrogation, I arrested him and forwarded to the court. I also collected a post-mortem report, and after completion and having found sufficient so-and-so. PW7 Subhas Boru has stated before me under section 161 of CRPC that altercation all started then about some boundary dispute between Kesaram Boru and Someswar Boru, son-in-law of Anil and Lakshmi Maya Bosumotari. Later on the same night, they had an altercation and Anil and his wife assaulted Kesaram too, which he sustained injuries and died today. Crossed by defense. So here, same thing, he is only lordship, second last para, PW1 Nirmal Sorgiari did not state before me that after returning from puja an altercation took place. So here he denied that PW1 had stated or PW2 had stated something to him. But this witness stated before me that my father told us that accused Anil Bosumotari and his wife Lakshmi assaulted me. That much he had stated, lordship. And then the PW10 who had conducted the inquest, and according to PW10, opinion is that as per statement of the witnesses, the death occurred due to assault on his body due to physical fight. This is the opinion on the basis of the statement of the witnesses, lordship. Then 313 statement, lordship, their 313 statement is only of total denial, lordship. Not given any explanation. They are only denial and they are innocent. That is what they have stated, lordship. So this is the fact of the case, lordship. Here, lordship, at that time, actually none had seen the incident, lordship. Although there are many persons are there and some contradiction is there, lordship. And both the persons were standing there, many other persons are also. Many other persons were also there. They stated that they came hearing Halla. So it cannot be denied that these two persons also came hearing Halla and may have, who have actually assaulted. That is not seen by anyone. Some quarrel may be there, some altercation may be there, and that also happened in a third person house, lordship. And whoever has stated that they have heard this, that They are all are interested witnesses, only the family members. And the wife came to know about the incident only after a later period, Lordship. And she have not even heard the incident. Now, Halla, she had not heard. Others have stated that, Lordship. Assault, Lordship, how that is also not denied by the doctor, Lordship, that he may have fell down, Lordship, because he was in a intoxicated position, Lordship, at that time. So these are
But there is dying declaration between
the declaration. It
before
cannot be.
PW2 and PW4.
That is only they have stated, but Lordship, one had also stated he regained senses at a very later part, but others have not stated that he was not in a unconscious position. They have taken him, but he was not unconscious. He was kneel down and bending. That is what other witnesses are saying. Had he had, whether he actually could identify these two persons, or whether they have stated that they had assaulted them. This immediately he had not stated. Had he been stated that the other persons were also have heard that, Lordship. PW2 and PW1, they are the son and daughter of PW. This is, Lordship. PW2, PW, whether the mother, PW2 is the daughter, but PW2 have not stated this to the IO also, Lordship.
PW2 has stated this to IO. Investigating officer in his deposition has stated that
No, 30.
page 30.
My father told us that Anil Basmatai is right.
That must say, my father told us that accused Anil Basmatai and his wife Lakshmi assaulted me. But that is, Lordship, but mother evidence, mother also stated that, but Lordship, other persons, she is an interested witness, Lordship. But actually assault is not seen by anybody else. And 2-3 persons are there who are independent witness. The incident took place in the house of Someswar Bora and Subhas Boro, Someswar Boro. These persons are all, in fact, all are on, except PW4. PW4 is also neighbor and nephew, Lordship. So all are family members, Lordship. Actually, who have assaulted, that is not seen. And at 10:30 p.m., whether he is capable of identifying them so clearly, Lordship, in a village area, Lordship, and in also in an intoxication position, Lordship, where presence of other persons are also there. And he came from others' house, he may fall down, Lordship. There may be altercation, but the benefit of the doubt should go in favor of the appellant, Lordship, because assault is not seen, neither the material exhibit was seized by the police, Lordship. And he was at his home for almost 14-16 hours, Lordship.
In fact, what I can see is there has been so many contradictions. In fact, PW1 also has contradicted. He did not state those things to the police, and the contradiction is proved. PW2 had also, there is some contradiction, but PW2, as your lordship has said, about the dying declaration, it stands. About the dying declaration, see, she said that her father had said, he said, that that's the son of the deceased. And doctor is also this. PW4 had also, there is contradiction that he saw in Someswar's house. What I can deduce the story, the prosecution story is perhaps like this. Of course, there are some contradictions that the deceased went to Subhas Boro's house for puja. And there he had some liquor and all, and then he was back. He went to his house. And after that, 3 a.m. or midnight, these two people went to his house, the accused persons, and then they brought him to Sumeswar's house. Sumeswar, there was a quarrel in the house regarding perhaps land matter, because a sketch map I have seen, both the houses are contiguous to each other. And then there was a fight, and then he was assaulted because dying declaration of the son of the deceased is there. As far as the prosecution story is this, and he was not taken to the hospital. Had he been taken to the hospital at right time, perhaps he would have survived. Because and one of them said that the injury was not so serious that there was any necessity to take, so he was not taken.
But
So-
there are rib fractures.
There are ribs fractures, yes, fractures on the ribs that will not be seen by others. He was assaulted by Lathi. Now, if we go with the evidence of the prosecution witness one by one, Lordship will see PW1. PW1 had stated that about the puja and then coming back, and then Lakshmi and Anil assaulted. Both accused came to the house of the deceased and again took quarrel. He did not say that these two accused person had taken him from his house. He did not say that, PW1. PW1 stated that accused had come to his house and then again a quarrel took place. And then he was assaulted. Hearing halla, I went to the house of the deceased and saw deceased was found bending. House of the deceased. He did not say house of Someshwar. But these two are contiguous. Place of occurrence, Lordship will see exactly in the boundary. Lordship may go to the sketch map. That is at page for 78. 78, Lordship can go. There, the place of occurrence is almost on the boundary of the house of Someswar and victim. So as far as PW1, he is not an, of course, the case is on circumstantial evidence. This, he did not see the occurrence. He simply saw him bending and these two were standing beside. And there was a lathi lying on the place of occurrence. But this again is contradicted. Police said that he did not see. So his statement goes. PW1 statement goes. Lordship will see the police's statement. The entire part goes. Why I'm showing before your Lordship is only to discard those evidences which are not necessary. Then we will come to those evidence which are important. So PW1, Lordship will see at page number 29. This is totally gone. Police said Nirmal Sargiari did not state before me that Lordship got page number 29, last paragraph. After returning from puja and altercation
He has not stated anything before police.
he had not stated anything before police. I have not seized any weapon in connection with the case. I went to the husband, bending, everything. Seen lathi, nothing stated to police. So PW1's examination in chief goes. In cross-examination, in fact, he stated in cross-examination, it is not a fact that so-and-so. So his contradiction was proved by him itself. So this goes. Then let us come to PW2. PW2, she is the daughter. She is the daughter, no? She is the daughter of the deceased. Kesharam was my father. And then what she said, after having dinner, we went to sleep. During that time, we heard halla in the campus of Someswar, who is the son-in-law of the accused person. In the said night, Siba Baru came to our house, woke us up, informed about the incident. We immediately rushed to the place of occurrence, took my father to his own house by Someswar Siba. When my father regained his senses, he told us that Anil and Lakshmi assaulted him. We advised to take our father. Let us go to the cross-examination of the police. Lordship will find it at page number 30. Anima Sorgieri did not state before me. My deceased father told us that the accused persons came to the house of the deceased and took him from the bed. My deceased father told us. Of course, during that time, we heard halla. So, Miss, in the campus, in the said night, Siba, of course, in the cross-examination, Lordship will see the difference is my deceased father told us that the accused person came to the house of the deceased and took him from the bed to the boundary. My deceased father told her, but in her examination in chief, she said as if she herself knew. She was there at the place of occurrence. At the night, having dinner, we went to sleep. During that night, we heard halla. Someswar, Siba Boro brought her. So as far as PW2 statement is concerned, it has some relevancy. In fact, the next line, Lordship will see. But this witness stated before me that my father told us that Anil and Lakshmi assaulted me. So as far as PW2 is concerned, the evidences has some value. Then Lordship will go to PW3. PW3 is the doctor, not required. PW3, he said ribs, fracture of ribs, 9th, 10th, and 11th.
There is someone has deposed that the deceased had consumed liquor on that day also.
Yes, that is established. That is in fact, number of them have said.
So at the time when he made his statement, what was his mental state? Whether there was some question, cross-examination?
Nothing. In fact, what the doctor said.
But it is on record that he was under consumption of
liquor. This is dead. But after getting assaulted to such an extent, whether there is any possibility that he won't speak the
And also
correct
its
thing.
time is also important to see, Lord.
3 a.m. no? How about
10 p.m. to 3 a.m.
incident took place.
Village place.
In fact, the trial court had not put much importance in the dying declaration. They have gone with the
On what trial court has relied?
circumstances. Lordship will see.
What are the circumstances?
Lordship
Only
will
their
see.
presence is there.
No, it is curled out at page 64. Page 64, Lordship will see. 64, Lordship got it, paragraph 35. The first circumstance is on the day of incident at around 9:30 p.m. Deceased after attending puja in the house of PW7. While returning home, altercation took place between accused person and the deceased. But this is again contradicted by PW1. The deceased used to consume liquor, and on a fateful night also he consumed liquor in the house of PW7 where he acted as priest in the puja performed. 3, hearing Halla, PW1 came out and saw the deceased in bending position and near him both the accused. This also goes. This is contradicted. PW4, hearing Halla, when came to the place of occurrence, saw the deceased in the boundary of PW8 and saw the deceased accused person standing. Perhaps this is also contradicted. There is contradiction in respect of PW4 as well. Then 5, after being assaulted when the deceased was brought home on regaining sense, he told before his daughter PW2 that accused so-and-so has taken him from the bed to boundary and had assaulted him. This was little more than what was in the records. Taking him from the bed is not there. This is contradicted. Since the time of oral information, the witnesses pointed both the accused person as perpetrator of crime. Then, as per postmortem report, sustained fracture of ribs. These circumstances, all a few of them will not stand in my humble submission. Lordship will go to paragraph. Now, I was just taking one by one the PWs. PW3, Lordship will leave it, the doctor. PW4. PW4 also there is a contradiction. Page number 30, Lordship will see. Siba Boro, who is alleged to have taken the deceased to his home. Siba Boro did not state before me, I saw Kesharam in the boundary of Somesha Bora. I saw accused person standing near Kesharam. During that time, Kesharam told me that he had been assaulted. Name was not there, but PW4, in his examination in chief, he said, I saw accused person standing, that goes. Then I, along with Somesha Boro, took the victim inside the room. That will stand. That will stand. That is not contradicted, taking him inside his room. During that time, Kesharam told me that he has been assaulted. This will also go. As we did not notice injury of the victim so serious, I could not take. So there is contradiction. The PW4 statements also goes only to the extent what it says is he had taken him to his house. Then PW5. PW5 is Junub Mushahari. He is the informant. And he said, PW5 also there is contradiction. Lordship will see at page 30. Now he is only hearsay evidence. parental house, my father also told me. And then he asked, acha. No, he is hearsay, but then the dying declaration is there, I think. PW 5. PW 5, yes, dying declaration, but then contradicted, it seems. Acha, the incident took place at that next day. My elder sister called me to a parental house stating so and so had assaulted. I met my father in injured condition. My father told me that Lakshmi and Anil assaulted him in the boundary of Someshwar Bora. Lottery will now turn to police's statement at page 30. Then it is contradicted. Police said that he did not say before me. So this dying declaration also goes PW 5.
Yes.
Then PW 6 is the wife, no?
No, no, 6 is the wife.
6 is the wife. Now her statement does not reveal anything. She said that I did not know. Morning only I came to know.
And she also told that her husband told her that she was assaulted. But she did not say so to the investigating.
If not, Lordship will again PW 6. Yes, page 30. My husband used to sleep at night. During that time, he told me that accused has assaulted me with a bottom after calling him out. Yes, this also gets contradicted. 6 also goes. Then 7 is already an hostile witness. I saw both accused person in the house of Keshoram. PW 7. He also in the house of this. In fact, this goes. Then PW 8 is hearsay. PW 8 is hearsay. When I woke up, I rushed to the spot and I saw kneel down and bend towards so and so. I heard from local public that so and so. But then PW 8.
He said only about Lakshmi Maya, not about Anil.
No, he heard from public.
Yes.
As far as he going to the house of I heard Halla near the house of Kesharam Bora. I rushed to the spot, saw Kesharam kneeling down and bent towards the bamboo fencing situated at the side of the road. Only that statement will not do. And he heard Lakshmi Maya had killed. That will only a hearsay evidence. Cannot be a rest gesture too, because none of them had stated to him. So what we are left is only with statement of the PW2, one dying declaration. And even the story is not established. He went to puja, he came back. Because that also stands contradicted. The entire story is contradicted.
Wife
fact-
doesn't say anything about that. That's why not saying
Her wife also did not say.
anything about the first incident, the puja, etc.
PW7, at whose house that Prasad and Puja went on, he also had turned hostile and he did not say all this. No, he did not say about the Puja
And
Tuja
wife
part.
came to know only at 3 p.m. Lordship. The incident took place in their house. All know, but the wife was just sleeping. That is also perhaps not believable. She came to know only at 3 p.m. when he asked for a glass of water. She came to know when he asked for a glass of water, but so much of hue and cry, so much of incidents, she was not even came to know anything. That is possibly much more improvement is there, Lordship.
What I find is even the story is not established. I may see the 161 statement once, whether this is at all the story. 161 statement, if I can see, because everyone is contradictory, even the story is not established. LCR to Jana. And dying declaration only PW2 will matter. What, English of person? English of person. The statement of Nirmal Sargiari, he said, I heard hue and cry and went outside and saw that our neighbor Siba and Somesa was carrying my father-in-law near the entrance gate of Someswar and learned that Lakshmi Maya and husband Nila has assaulted him and some bland object to which he fell down. He was shifted to his house, which was nearby. We thought the injury was not severe, but then he said something. He saw that Siba and Someswar was carrying his father-in-law. Last night, my father-in-law, Kesharam, had an altercation with her neighbor Lakshmi. At around 10:30 p.m., I heard hue and cry, went outside, saw that our neighbor was carrying my father-in-law to his house. And he learned that Lakshmi Maya had assaulted him. This is what Nirmal Sargyari said. Anima Sargyari, that is PW2, no. PW2 said, and a daily wage and last night at around 10:30, my father Kesharam was assaulted by Anil and Lakshmi of same village to which my father was injured. Today at so-and-so, my father got serious and died. No, she did not say anything. It's totally a hearsay. Then Someswar, at whose house that had taken place.
She has not stated that father told her.
No, she had not stated. No, I'll just read it out again. 12:50, wife Lakshmi Basuma, same village to which my father was injured. Today at 12 p.m. noon, my father got serious and died due to the injury he sustained last night. My father told me before he died that he was assaulted by Anil, she said. That is how police have stated.
Now, what is the significance of this statement?
Now, as far as dying declaration made before Anima Sargyari, that is proved. That stands. That becomes an evidence. Because police have stated clearly.
Now, is it sufficient to convict him?
No, dying declaration. A dying declaration can be a sole ground, but prudence requires that it needs to be corroborated. Oral dying.
Moreover, in this case, when admittedly he was under the
Influence of the liquor.
influence of liquor.
Yes. But then this dying declaration was in the next morning at 12 p.m. Today at around 12 p.m.
Some
noon.
said he died at 10 p.m.
Some said
Some
that.
say he died at 10 p.m. Wife, perhaps wife said that.
Someswar also said about the altercation.
At about 10 a.m., my husband died. That is the evidence of PW6 wife.
No, they might be little, confused with the time. I'll see what is the time of death. Time of death too. Police কখনো সরি পুলিশে কেতিয়া মৰা বুলি কৈছে পোষ্টমৰ্টম inquest was done at what time? 4 p.m. I remember it was down at 4 p.m. Now, approximate time of death 90. With GM reported.
19th February has risen.
A few hours here and there will not matter. She is specific in saying that at 12 he made the confession, dying declaration. And they opened the diary at 3:20 p.m. So this will also not show the time of death.
মা কোনে কৈছিল মাকে কৈছিল কেতিয়া কৈছিলে 10টাত মৰা বুলি কোনে কৈছিল মাকৰ নামটো যোগেশ্বৰী Yogeshwari's Musahari's statement I don't get before the police. Neither. Yogeshwar Musahari. No, contradiction আছে তো. There is.
So the most important evidence on prosecution side is PW line declaration given before PW2, because that was regarded as one of the incriminating circumstances.
Yes.
Now, we have to see that how much it can be relied upon. What is your son?
No, oral dying declaration has to be again supported by other circumstantial
Other circumstantial.
evidence. So other circumstantial evidence
Other circumstantial evidence are not established.
not established. Because he's bending down, he being found at Someshwar place, all are being contradicted. PW4 contradicted 5, 6, 7 also contradicted 6. Contradicted
The
1.
time of FIR is 20-23 hours. So possibly it's 10-23 hours.
No, time of FIR is 22 hours is the occurrence.
No, ইয়াতে এইখনত আছে না। Date and time of FIR 18 to 2018, 20 এইখন 20-23 hours. So 20 হলে তো 12 plus 8, 20. So
2023 means 823.
823. 823. And as per PW1, but mother said it is Nirmal Sargiari had lost the FIR, but PW4 said that possibly before him no FIR was lost. That is by Juno Sargiari.
For formal FIR and in
GD entry was there.
GD entry was there.
But this FIR, it is shown as FIR by Juno.
No, GD entry was there, it cannot be read. Really. This was a 320.
This 823 is by Juno Musahari, so this is the formal FIR.
It was in the 5 This is 320 GD entry. Oh, but real one point at home. That's not true. Who had given the information?
It is Juno Musahari.
Juno.
It is Juno Musahari.
Yes, it's Paisarova. Itia Srimati Olima. This was a 320 Bojar. It started with the GD entry. No, Srimati Anima Sargari, Sami Sri Nirmal Sargari, and Junu all had gone to the police station and informed.
But that is not stated by Nirmal also. No? According to him, he had only went. Then, according to then I went to the police station to inform the meter. He had not stated that he went along with so many people. And
But GD entry shows all three had gone and informed.
instead of taking the person to the hospital, all of them went to the police station.
the FIR was lost after he died.
After he died. It was lost
Yes.
at 8.
8.
No?
So he died possibly at night or
Because after this GD entry, the investigation started. And at 3:50, statement of complainant told him. Oh. 3:50 in fact, this
when
FIR
we went to Los the Ajahar, according to PW4, then we asked accused person to our house to see my father and to take him to hospital, but they did not come. Then I went to the police station to inform the meter. In the meantime, my father died. So possibly he have not reached while his father was died, he is alive. After reaching from police station, possibly already he had died. From this, it looked like that only, Lordship. Police came and taken the dead body to the hospital for postmortem examination.
Okay. I'm reserving
Lordship.
Ms. B. Sharma, learned amicus curiae. Also Ms. S. Jahan, learned additional public prosecutor. Hearing concluded, judgment reserved.
Perhaps because the FIR or because the dying declaration becomes little unbelievable. And since it's an oral one and there are no corroboration, perhaps this will not lie, in my humble submission. I'm okay.
Offline.
Oh. Yes, Ms. Verma.
May it please your lordship. In this matter, my lord, accused is convicted under two sections, my lord. That is for 326, my lord. It's 7 years with fine of 5,000 rupees in default 3 months. And another one is 307 with a fine of 10,000 rupees for period of 6 months, my lord, in default. Judgment date is 31st of May 2019, ma'am. In sections case number 03/2013.
Yes.
In this matter, my lord, I have Assamese versions of evidences, my lord, that is being given to me, my lord. As per FIR, my lord, that is exhibit 1, and it was
The additional people who you will read. Okay,
She's come, she'll come. She has seen the case.
you will require the LCR. I think. What should we do? Should we wait till Ms. Bora?
Let me start, my lord.
No, she is coming on. She'll be reaching us.
She said that she has already seen the relevant evidences, my lord. Let me start. By that time she can join, my lord. FIR is exhibit 1, my lord, that is 8/10/2012, my lord.
Exhibit 1 is FIR.
Yes, my lord.
Okay, let me see. Dated?
Dated 8/10/2012.
Yes,
May I read, my lord? It is in vernacular version. my lord.
just a minute. Yes.
বিনীত নিবেদন এই যে এজাহাৰ একে গাঁৱৰে এজাহাৰকাৰী নিজৰ বৰদেউতা শ্ৰী পৰেশ বৰঠাকুৰ বিশ্বনাথ ঘাট শিৱৰ ওচৰত থকা জাগ্ৰা বিশ্বনাথ ঘাট I could not read the Assamese file. ওচৰত থকা জাগ্ৰত বাবাৰ মন্দিৰৰ পূজাৰী হয়। আজি ইংৰাজী 8-10-2012 তাৰিখে পুৱা 10 মান বজাত উক্ত মন্দিৰলৈ বুলি গৈ পৰেশ বৰঠাকুৰ পূজা অৰ্চনা কৰিবলৈ খোজকাঢ়ি গৈ থাকোতে উপৰোক্ত আসামীয়ে ঘৰৰ পদূলি মুখত ৰাস্তাৰ উপৰোক্ত আসামীয়ে হঠাতে চোকা দাৰে সৈতে ঘপিয়াই শ্ৰী পৰেশ বৰঠাকুৰক গুৰুতৰ জখম কৰে। বৰ্তমান গুৰুতৰ জখম অৱস্থাত শ্ৰী পৰেশ বৰঠাকুৰক বিশ্বনাথ চাৰিআলি অসামৰিক চিকিৎসালয়ত ভৰ্তি কৰাই চিকিৎসা কৰাই থকা হৈছে। Informant is his nephew, my lord. Due to grievous hurt by the accused, the person concerned was hospitalized for 5 days, my lord. Thereafter, he recovered, my lord.
The conviction is under
Under 326 and 307, my lord.
326, how many, what was the sentence?
And for 326, period of 7 years and to pay fine of 5,000 rupees in default to undergo further rigorous imprisonment for a period of 3 months.
And for 307,
307, my lord, it is 10 year rigorous imprisonment for a period of 10 years and to pay fine of rupees 10,000 in default to undergo further rigorous imprisonment for a period of 6 months. Both the sentences of imprisonment shall run concurrently.
so the allegation was he was assaulted with a dao.
Thou, my lord. Before going into the evidences, my lord, I would like to present the story in nutshell, my lord. This informant is the nephew of the victim, my lord. And while his uncle was moving towards the Mandir, my lord, Vishwanath Baba temple, my lord, and then the accused was standing in front of his house, and that victim proposes him to clean up his jungles in his house, my lord. And all of a sudden, he took the dao and 3 blow was inflicted upon the accused person inflicted upon the victim, my lord. As a result of which he was hospitalized for 5 days. Thereafter, he recovered, my lord. And there was no eyewitnesses, my lord. Prosecution story is on the basis of circumstantial evidence, my lord.
The victim did not examine.
Deposed. He is PW2, my lord.
He is the himself eyewitness.
But other corporation, others are
corpor-
not. The other are corroborating, but straight away PW1 is, my lord. Insofar as while this case was listed earlier, my lord, one thing is there, while we were going through the record, my lord, in respect of 161 statement of the victim, my lord, as a statement of the accused person, my lord, some kind of mental illness can be depicted from the evidences, my lord, but prosecution never led to that extent, my lord. On that count, Honorable Court has asked for a report from the jail authority.
What report suggests?
This is on the basis, according to that report, my lord, on the basis of for mental condition, my lord, mental health of the.
What was the report?
Report says that he was suffering from some mental ailment. It is already flagged in my lord, which court record, my lord, that says that it is hereby stated that the physical status of convict Sri Digamani Das is found to be stable. However, on consultation with mental health specialist from LGBRMH Tejpur, it has been found that he has had history of mental illness since 2013, diagnosed as F20, and has thereby been advised admission at LGBRMH on 10/8/2023. Thus, based on the past records and present advice by the specialist of LGBRMH, it can be stated that the mental health status of the convict, Sri Digamani Das, is not stable and he is need of treatment at LGB RIMH, that is Mental Hospital in Tezpur, my lord. That report has produced before Honorable Court pursuant to an order dated 15/6/2003, my lord. 2023, my lord.
Thereafter,
Thereafter, case was listed for hearing today, my lord. One occasion it was listed there, but Honorable Court, due to paucity of time, it was fixed for 2 weeks, after 2 weeks, my lord. And that is on 3/8/2023, my lord. It was fixed on 11/8, and thereafter it is listed today, my lord. So far as evidences are concerned, let me, my lord, read the PW1, my lord. PW1 is পৰশমণি বৰঠাকুৰ। মই এজাহাৰকাৰী আছামিক চিনি পাওঁ। 8-10-12 তাৰিখে দিনৰ 10 মান বজাত PW1 মানে মই এজাহাৰকাৰী আছামিক চিনি পাওঁ। 8-10-12 তাৰিখে দিনত 10 মান বজাত মোৰ
with
বৰদেউতা,
PW1,
this is nephew of the
he's the informant.
informant, my lord, and as well as nephew of the victim, my lord. আঠ, 10, 12 তাৰিখে দিনৰ 10 মান বজাত মোৰ বৰদেউতা পৰেশ বৰঠাকুৰে বিশ্বনাথ ঘাটৰ মন্দিৰৰ পূজা কৰিবলৈ গৈ থাকোতে আছামীয়ে তেওঁৰ ঘৰৰ সন্মুখত ৰাস্তাত বহি আছিল। তেতিয়া আছামীক পৰেশ বৰঠাকুৰে তেওঁৰ ঘৰত হাজিৰা কাম কৰিবলৈ আৰু জংঘল কাটিবলৈ কোৱাত আছামীয়ে হাতত থকা দাৰে পৰেশ বৰঠাকুৰৰ মূৰত আৰু ডিঙিত খপিয়াই গুৰুতৰ জখম কৰে। পিছত বিশ্বনাথ চাৰিআলি চিভিলত 5 দিন থাকি পৰেশ বৰঠাকুৰে চিকিৎসা কৰায়। Exhibit 1 এজাহাৰ, Exhibit 1-1 তাত মোৰ চহী। And cross, my lord. আছামীৰ ঘৰ মন্দিৰৰ কিনাৰত আছামীক আগৰ পৰা চিনি পাওঁ। ঘটনাৰ সময়ত বৰদেউতা পৰেশ বৰঠাকুৰ অকলে আছিল। ঘটনাৰ পিছত গাঁৱৰ ৰাইজে বৰদেউতাক চিভিললৈ অনাত ময়ো তালৈ আহোঁ। মই ঘটনা দেখা নাই। সত্য নহয় যে আছামী পাগল মানুহ। There is a suggestion regarding mental condition of the accused, my lord. PW2 is the victim himself, my lord. Sri Paresh Borthakur. এজাহাৰকাৰী মোৰ ভতিজা। আছামীক চিনি পাওঁ। 8-10-12 তাৰিখে দিনৰ 10 মান বজাত মই বিশ্বনাথ ঘাটৰ মন্দিৰত পূজাৰী হিচাপে সেইদিনা পূজা কৰিবলৈ গৈ থাকোতে বাটতে আছামীক বহি থকা দেখি মই আছামীক কওঁ যে আমাৰ ঘৰৰ জংঘল অলপ চাফা কৰি দিব লাগে। আগতেও আছামীয়ে আমাৰ ঘৰত হাজিৰা কৰিছিল। মই আছামীক জংঘল কাটিবলৈ কোৱাত আছামীয়ে মোক দাৰে মূৰত 3 ঘাপ মাৰে। তেনেতে আছামীৰ হাতৰ পৰা দাখন পৰি যোৱাত মই ঘটনাস্থলীৰ পৰা ঘৰলৈ বুলি আহি ৰাস্তাতে বহি পৰোঁ। ৰাইজে মোক বিশ্বনাথ চাৰিআলি হস্পিটেলত আনি 5 দিন চিকিৎসা কৰায়। আছামীৰ ঘৰ মন্দিৰৰ লগতে ইন ক্ৰছ মাইলত আছামীৰ ঘৰ মন্দিৰৰ লগতে ঘটনাৰ আগতে আছামীৰ লগত মোৰ কোনো কাজিয়া নাছিল। আছামীয়ে মোক এখন দাৰে কাটে। ঘটনাস্থলীৰ কিছু আঁতৰত নিয়া দাসৰ দোকান আছে। সত্য নহয় যে আছামী ঘৰৰ সময়ত মানসিক ৰোগী আছিল। Here also, my lord, victim himself said regarding the incident, and as well as in cross, he specifically admitted that there is no quarrel between accused and the victim, my lord. And it is also stated in cross that suggestion is there regarding mental condition of the accused, my lord. He is denying that. PW3. That is Hiranya Das, my lord. আসামি আৰু গোচৰীয়াক চিনি পাওঁ 4-10-12 তাৰিখে দিনত ঘটনা হয়. I'm sorry, my lord, I have told regarding FIR, it is in Assamese, it is 4, my lord, it's not 8, my lord, that I may be corrected, my lord. 4-10-12 তাৰিখে দিনত ঘটনা হয়. উক্ত দিন আসামী দিগমণিয়ে বিশ্বনাথ ঘাটৰ মন্দিৰৰ পূজাৰী পৰেশ বৰঠাকুৰক কাটিলে বুলি মানুহৰ মুখত শুনি ঘটনাস্থলীলৈ আহোঁ. তেতিয়া জখমীক হস্পিটেললৈ নিয়াত মই তেওঁক লগ নাপালো. আসামীৰ পৰা গাঁৱৰ ৰাইজে দাখন কাঢ়ি লয়. মই পুলিচক খবৰ দিওঁ. পুলিচ আহি ঘটনা কৰা দাখন আমি চমজাই দিয়াত জব্দ কৰে. Exhibit 2 জব্দনামা. Exhibit 2-1 তাত মোৰ চহী. Exhibit 1 Material Exhibit 1 উক্ত দাখন আজি আদালতত দেখিছো. পৰেশ বৰঠাকুৰ ডিঙিত জখম দেখো. ঘটনা ইন ক্ৰছ মাইলত. ঘটনা বৰলা মিলৰ ওচৰৰ জাগ্ৰত মন্দিৰৰ ওচৰত ৰাস্তাত হৈছিল. মোৰ ঘৰ ঘটনাস্থলীৰ পৰা আধা কিলোমিটাৰ দূৰত. আসামীৰ পৰা 6-7জন আসামীৰ ল'ৰা 6-7জন লগাই দাখন কাঢ়ি পুলিচে আসামীৰ পৰা 6-7জন ল'ৰাই দাখন কাঢ়ি পুলিচক দিয়ে. Exhibit 2 জব্দনামাত মই থানাত চহী দিওঁ. জব্দনামাত কি লিখা আছে নেজানো. জব্দনামাত জব্দনামাত এইটো কি লিখিছে? ভাল মানুহৰ অন্য মানুহৰ ঘৰতো থাকে. মই হস্পিটেললৈ যাওঁতে পৰেশ বৰঠাকুৰে মোৰ আগত তেওঁক আসামীয়ে দাৰে কটা বুলি কৈছিল. This PW3, my lord, corroborated the informant as well as PW2, my lord. Next one is PW4, Niranjan Das. He is an independent witness and businessman, my lord. I know both the parties. About 3 years ago, one day at about 9-10 AM, I, along with police, went to place of occurrence and saw that the accused Digamani Das was tied with a tree, and village people told me that accused assaulted Pujari Paresh Bothakur. The village people handed over a dowry to police. In Exhibit 2 is my signature. In cross, the occurrence took place near the house of the accused person. I have not seen the occurrence. He is a hearsay evidence, my lord. Only from the village people he could known about the incident, my lord. And he has proved the Exhibit 2 and 2, my lord. PW5, Mrs. M. Dev. She is a housewife, an independent witness, my lord.
Senehi Das.
Srimati Senehi Das. I know both the parties. About 3 years ago, one day at about 11 AM, the village people told me that Digamani Das assaulted the Pujari Bothakur, and accordingly, he sustained injury and the village people took him to the hospital. In cross, she said she has not seen the occurrence. Here also, informant is corroborated by, she has corroborated the informant's version, my lord, as told by him. Neither she and she has not seen the occurrence. PW6, Sri Rajiv Sharma. He is a businessman. I know both the parties. About 3 years ago, at about 9 a.m., I heard from the villagers that accused Digamani Das assaulted Pujari Paresh Borthakur, and hearing the same, I went to the place of occurrence. Due to the assault, Pujari sustained injury. In Exhibit 2, Exhibit 2.3 is my signature. In cross, he stated, I have not seen occurrence. I do not know what is written in Exhibit 2. He is also a hearsay evidence, my lord. He has not seen the evidence. PW 7, Mohammad Shamsuddin. He is SI of police, my lord. On 4/10/2010, I was at Biswanath Sariali PS. On that day, Hiroino Das informed that accused Digamani Das assaulted Paresh Borthakur with dao, and the villagers brought the injured to civil hospital Biswanath Sariali. Hearing the same, I went to place of occurrence and found the accused at place of occurrence with dao. Accordingly, I seized dao. In Exhibit 2, Exhibit 2.4 is my signature. I took the accused person in my custody and recorded the statement of witnesses. And as the accused was injured, I took him to civil hospital for his treatment. I also drew the sketch map of place of occurrence. Exhibit 3 is the sketch map and Exhibit 3.1 is my signature. On the same day, the nephew of the injured filed FIR. Thereafter, I recorded the statement of the accused and arrested him and produced him before the court on 17/10/2012. I collected the medical report and on 25/10/2012, I filed the charge sheet after completion of my investigation. Exhibit 4 is the charge sheet and Exhibit 4.1 is my signature. In cross, he has stated at 7:30 p.m. FIR was filed. The says thou is not in the court today. It is not a fact that I have not investigated the case properly. Here only, my lord, statement, what statement he has recorded from the other witnesses, except that Hiroino Das, who has informed, he has not stated anything regarding that other depositions, my lord. As well as he has not seen the material exhibit in court also. And so far as he has stated that he recorded the statement of the accused person and arrested him and produced him before the court on 17/10/2012, my lord. PW 8 is the medical officer, my lord. His name is Dr. Prashanto Bora. On 4/10/2012, I was working as senior medical and health officer 1 as subdivisional civil hospital, Biswanath Sariali. On that day at 11 a.m., I have examined and
Which line?
third line, my lord. On this day at 11 a.m., I have examined and
Leave that word.
Sri Paresh Borthakur, 55 years, son of late Bhola Borthakur of village. That could not be read, my lord. Post Office Biswanath Ghat in connection with police registration
Admitted. The word is admitted.
admitted. That might be. Which police requisition received from Biswanath PS, Biswanath Seriali PS, case number nil, dated 4/10/12, is escorted, I suppose, by UBC Yogen Deka, OPD registration number 41894, medico-legal, perhaps it is registration number 2049, indoor registration number 1576.
You may read the injuries and opinion.
Yes, my lord. Injuries on local examination, number 1, deep cut injury, left side of the neck, 7.5 cm, which muscle deep and active bleeding. Injury number 2, deep cut injury, left frontal. This could not be very
Region.
region, 5 cm scalp deep, which or frontal of frontal bone. Number 3, deep cut injury, left portion region, scalp deep, perhaps it is 6 cm. Judgment, my lord, it is depicted. Which into 5 cm, my lord. X-ray skull was advised, report not received. He was
Discharged from the.
discharged on 8/10/2012, my lord. In remarks part, it is stated grievous injury caused sharp cutting light weapon. Exhibit 5 is my medical examination report, and Exhibit 5(1) is my signature. In cross, it is stated the age of injury is not mentioned in my report. The injuries sustained may also be caused after falling on a sharp object. It is a fact that I have not mentioned the police station case number in my report. The report is not connected with the instant case. Here, my lord, the medical witness doctor has deposed regarding the 3 kind of injuries, my lord, with a diameter of 7.5 cm. One is 5 cm, another is also 5 cm, and in a vital part of the body, my lord.
It corroborates the testimony of the victim. He
Yes,
said
my
that
lord. While
3 assaults.
3 assaults, it is corroborated accordingly, my lord. 313, next one is 313 statement of the accused, my lord, where he has denied all the suggestive questions, my lord. And so far as one part it has given to me regarding that hearing of question on sentence, my lord. That is in respect of sessions case number 3/13, my lord. Here, one thing that accused has stated, my lord, hearing the question of sentence with regard to the convict Sri Nigamani Das. While sentence was pronounced, my lord, his answer is, মই এটা দুখীয়া ঘৰৰ ল'ৰা, মোৰ ঘৰত মা দেউতা থাকে, বাইদেউ দুজনীক বিয়া দিয়া হৈছে, বেলেগে থাকে। মোৰ মন্দিৰৰ ওচৰত সৰু দোকান এখন আছে। তেওঁক মাজে মাজে সহায় কৰিছিল। দেউতাই মাজে মাজে সহায় কৰিছিল। দেউতাই হাঁহ কুকুৰাবোৰ তেওঁৰ হাঁহ কুকুৰা পোহে। তেওঁৰ বয়স 60 বছৰ মান হৈছে। মই অনুতপ্ত, কেনেকৈ উক্ত মই ইমান জঘন্য কাম কৰিবলৈ পালো মই নিজে নাজানো। মোক দয়া কৰি লঘু শাস্তি প্ৰদান কৰে যেন। So far as analysis of the evidences are concerned, my lord, lordship may turn to the judgment, my lord. From para 19 onwards, my lord. Perhaps in paper book it is page 36, my lord. Para 19 onwards, that analysis has taken place, my lord. 19 and 20. In other, from paragraph 7 to 18, discussions were going on, my lord. I am not reiterating the same, my lord. Para 19 of the judgment, my lord. Thus, from the evidence of the various prosecution witnesses, we found nothing to doubt the veracity of cohesive prosecution evidence that on that day, the accused had assaulted the victim with a seized material exhibit 1, a sharp cutting instrument on his head and neck, causing grievous injuries on his person. However, from the evidence of the witnesses as discussed above, we find nothing that shows that the accused has wrongly restrained the victim on the said morning when he was on his way to the temple. Therefore, I find no evidence against the accused to convict him under section 341 IPC. The accused is therefore acquitted from the said charge. While scrutinizing the evidence, para 20, my lord, while scrutinizing the evidence as discussed above, we find that the cohesive testimony of the prosecution witnesses show that the accused had assaulted the victim with dao, which is a sharp cutting instrument and caused grievous injuries on him. The evidence of PW2 is supported by PW8. The victim has already stated sustained cut in grievous injuries on his head and neck, which are vital parts of a human body. Any prudent man having reasonable knowledge would have known that any cut injury caused on such vital part of the body of a person, that too with a sharp cutting weapon of the dao, may lead to death of the victim. The said accused is found to have assaulted the victim with the sharp weapon and with knowledge, and under such circumstances that by that act he caused death of the said victim, he would have been guilty of murder. 21. The credible, consistent, and inspiring evidence available on record, I leave no doubt in my mind to finally hold the accused Nigamani Das guilty of offences charged against him under section 326, 307 IPC beyond all reasonable doubt. In the result, the prosecution is held to have succeeded in establishing the charges against the accused Nigamani Das under section 326, 307 IPC. He in the consequence is convicted under section 326, 307 IPC. Next para, I have heard the convict on the question of sentence to be passed against him, which is recorded in a separate sheet. The convict Digomanidas has stated that he has his parents in his house. His two sisters have already been married and they stay separately. He used to run a small shop near the Jagra temple. His father is about 60 years old and he used to help him in running the shop. He also earns by rearing poultry. He further expressed that he has repented for the misdeed and stated that he is unaware as how the incident could happen. He pleaded for leniency. Next is my lord sentence, sentence part, para 23. Section 320 CRPC prescribed for imprisonment of life or with imprisonment of either description for a term which may extend to 10 years and shall also be liable to fine. Section 307 IPC, on the other hand, prescribes for punishment of either description for a term which may extend to 10 years and shall also be liable to fine. But the provision further states that if hurt is caused to any person by such act, the offender shall be liable either to imprisonment for life or to such punishment as he is herein before mentioned. In the discussion made above, we have noticed that convict has inflicted grievous hurt on the vital parts of the body of the victim with a sharp weapon. Having regard the convict Digomanidas on the question of sentence, considering the materials on record, taking note of the severity of the offences with regard to the multiple injuries inflicted on victim by the convict, which reveals his intention to commit the offence, the amount of cruelty and animosity with which the offences were committed, and also by taking note of the punishments prescribed for the offences, he is sentenced to undergo rigorous imprisonment for a period of 7 years and to pay fine of rupees 5,000. In default, to undergo further rigorous imprisonment for period of 3 months under Section 326 IPC. Further, he is sentenced to undergo rigorous imprisonment for a period of 10 years and to pay fine of rupees 10,000. In default, to undergo further rigorous imprisonment for a period of 6 months under Section 307 IPC. Both the sentences of imprisonment shall run concurrently. The period of detention already undergo by convict, if any, be set off. The fine, if realized, be given to the victim, Sri Paresh Bhattakur, as compensation. Next is the order, my lord. Page 20, para 25. In this matter,
Skip that.
yes, my lord. In this matter, my lord, for a moment, I would like to request your honor to see the 161 statement of the accused, my lord.
Yes.
May I read, my lord?
Yes.
মই মোৰ নাম ঠিকনা ওপৰত দিয়া মতে সত্য। মই জবানবন্দী এই যে যোৱা ইংৰাজী 4/10/2012 তাৰিখে মই পুৱা 10 মান বজাত মোৰ ঘৰৰ ওচৰত আছিলো। জাগ্ৰা বাবা মন্দিৰ মোৰ ঘৰৰ ওচৰত।
You just bring him in. Just.
I have flag marked it, lordship. In my paper book, my lord, set of papers, it is marked as pagination in 14. Probably Assamese Western paper is 14 page.
Yes.
Selected papers.
Yes. Yes. Yes.
মোৰ নাম ঠিকনা ওপৰত দিয়া মতে সত্য। মোৰ জবানবন্দী এই যে মই যোৱা ইংৰাজী 4/10/2012 তাৰিখে মই পুৱা 10 মান বজাত মোৰ ঘৰৰ ওচৰত আছিলো। জাগ্ৰা বাবা মন্দিৰ মোৰ ঘৰৰ ওচৰত। পূজাৰী পৰেশ বৰঠাকুৰ উক্ত মন্দিৰৰ পূজাৰী হয়। যোৱা ইংৰাজী 4/10/2012 তাৰিখে পুৱা 10 মান বজাত মই ঘৰৰ ওচৰত ৰৈ থকা অৱস্থাত পূজাৰী পৰেশ বৰঠাকুৰ খোজকাঢ়ি গৈ থকা অৱস্থাত মোৰ ঘৰৰ বাৰী জংঘল চাফা কৰিব কোৱাত মই তেওঁক পিন্ধি থকা গেঞ্জি দাঙিব কওঁ। গেঞ্জি দাঙিব ধৰোতে তেওঁ মোৰ হাতত থকা দাৰে ঘপিয়াই দিয়াত প্ৰথম ঘাটো মূৰত বাওঁ ছাইডত, 2 নং ঘাটো ডিঙিত, 3 নং ঘাটো পিছফালে মাৰি দিয়াত তেওঁ ইয়াৰ পৰা গুচি যায়। মই ঘৰৰ পৰা পলাব ধৰোতে ৰাইজে মোক ধৰি বান্ধি আটক কৰি মাৰধৰ কৰে। পাছত পুলিচক চমজাই দিয়ে। পূজাৰীক মই এনেয়ে ঘপিয়াও। পাছত উক্ত দাখন পুলিচে মোৰ পৰা জব্দনামাৰ সাক্ষাতত জব্দ কৰে। মই চহী দিওঁ। মোৰ ক'ব লগা ইমানেই। Lordship, on the analysis and the evidences that has been deposed, my lord, so far as section 326 is concerned, that assault is being proved, my lord, by using that sharp weapon, my lord. That the accused has also stated before police, and that statement is recorded by police, as well as victim and other corroboration is also there. So far as motive is concerned, my lord, under 307 IPC. So that in statement of the victim, my lord, that is PW2, in cross, he has specifically mentioned that there is no such animosity with that accused person, my lord. And if we correlate with the evidence of 161, though it is not a substantive evidence, my lord, it has been proved by the SI PW8, my lord. He has mentioned that he has deposed, accused person has deposed before him. If we go by the contents, my lord, there is no such, it is not found any reason regarding animosity or cause of death. It is somehow, some abrupt statement has been, my lord, stated in.
There is no motive.
No motive at all, my lord. To that extent, in sentence hearing statement also, he is repentant, but he doesn't know how he could have done such an act, my lord. On that count, that medical report was called for, whether regarding his mental statement of the accused person, my lord. So as such, in Hori Singh case, my lord, probably it is
Yes.
1988 for Supreme Court, my lord, 551. Where section and paragraph, my lord, 7, though factually it is a different case, my lord, factual part, but so far as intention part and knowledge part is concerned, Honorable Court has stated, my lord, regarding 307 may not be attractive while this intention and motive is absent, my lord.
But
So-
intention is different, motive is different.
My lord, but here in case, my lord, nothing has been sustained from the evidences that is being placed before Honorable Court. Only assault is there, medical evidence is proved, my lord. To that extent, I am not denying, my lord. That cannot be discarded. But without any rhymes and reason, whether a reasonable person have inflicted such a grievous hurt to the victim, my lord, as the victim himself deposed before learned court below that he has no such animosity. Then it is a procedural lapse on the part of, while establishing the case of 307, my lord. Because without any motive and intent, without that reason of that assault, it is not being reasonably analyzed, my lord. Neither any of the evidences clearly stated regarding the animosity or any reason for which that victim has assaulted and the accused has assaulted the victim, my lord. And so far his mental condition is concerned, my lord, he might not be, he might be suffering from some mental illness, but as that occasion had not been arisen to test it in a proper manner, probably it was not done by the prosecution also. But totally that motive is absent, my lord, so that till today he has undergone imprisonment of 4 years, 8 months, 10 days, my lord, from the date of judgment. So here, my lord, I am in in the light of judgment, my lord, 1988 for SCC 551, my lord, horizing as paragraph 7. It, I may pray for, I'd like to pray for his set off for the rest sentences, my lord, as also a report from that concerned medical officer has come. I don't know and what stage he is undergoing that treatment or not, or whether he is being provided or not also, my lord. Without any rhymes and reason, though heart injury is there, but reason is not stated anywhere regarding that cause. And in the light of evidence, cross-examination, clear evidence, admission is there on the part of victim that he has no animosity with the accused person, my lord. To that extent, I am praying for set off also his rest part of imprisonment, my lord, on the ground of his mental condition and in lapse of procedural aspect regarding establishment of case under 307 IPC, my lord. This is.
May I please, your lordship? This appellant is convicted under section 302 IPC, with section, it's not 326, with section 307 of IPC, lordship.
You have 15 minutes on.
Lordship. Very short, already my knowledge fan has vividly.
You just tell the points.
Yes, lordship.
did
The
not-
thing is that here the PW2, PW8 is a vital witness. PW2, he's the victim. And lordship, victim himself stated that he has sustained grievous injuries, and that injuries were inflicted by the accused appellant, and that is well proved by PW8, who happens to be the medical officer, and his PW8's evidence is found to be truthful and corroborative and in regard to that of the injuries that is sustained by the victim, that is as described by PW1. And there is no evidence on record to show that injuries were sustained by the victim due to any other falling on the part of the victim on a sharp object as suggested by the defense side. And lordship, victim has sustained grievous injuries, and there is no any dispute to that regard. And on the vital part of the body, that is head, neck, and lordship, so far as mental health conditions status report is concerned, that has already your lordship has perused. So since 2013, he has got this mental problem. But the date of occurrence is in the year 2012, that is 4/10/2012. lordship.
Okay.
So lordship, if before declaring any person to be insane is not a unsound mind of a person, so that his prior conduct and at the date of incident and after that, all this conduct has to be taken into consideration. But so far as report is concerned, since it is from 2013 onwards, so to that effect, I don't think he's an insane person at that relevant point of time. And PW2 has clearly stated that at that time of occurrence, he was not a mental patient. And that is no such suggestion was put by the defense side to any other prosecution witnesses, whether he was mentally ill. So that is not, and that means he's a sound mind in a very good state of mind. He has done that. He has inflicted injuries to the victim, and that is well proved by the PW 2, and which is also corroborated by PW 8. And it is also supported by the medical evidence. So I think this is a fit case for granting, imposing him sentences under section 307 and 326 of IPC.
So your submission is that no interference is required.
Lordship.
Regarding her submission regarding quantum of the sentence,
Yes.
considering the fact that
Yes, because the maximum period is 10 years, Lordship. So he has not undergone half of the punishment, Lordship. It's only 4 years, 8 months, 14 days. So let him finish half of the punishment, then Lordship can decide. Because otherwise the prima facie case is made out from the depositions of the vital witness, that is PW2, who is the victim himself. And in 161 also, he has, the accused has categorically stated that he has sustained injuries on the victim. And in
161 is
that is not
Not a substantive
bit of evidence, but it can be taken as a contradiction. It can be used as a piece of evidence because 313, he has total denial on his part that he
Yes,
doesn't know anything, he has not done anything. So I found there is a contradiction.
no. 313 was during trial.
Lordship.
Before he was declared a convict.
Lordship.
So he was contesting his case.
Lordship.
Therefore
By
denied.
himself.
Lordship.
Sentencing, he was praying for lesser sentence.
Lordship, that is also.
Therefore he revealed,
Lordship.
but that cannot be taken into consideration
Lordship.
while considering.
Otherwise, on the vital issues, material parts,
Okay.
Lordship, that is well put.
Third, Miss M. Burman, amicus curiae, appearing for the appellant. Also, Miss S. H. Bora, running additional public prosecutor. Hearing concluded, judgment reserved.
Obliged.
Finish. Abbas.
May I please your lordship? I am appearing on behalf of Mr. P. Mahanda. I am for item 42. I pray to your lordship to kindly take the matter on some other day, maybe next week.
Why? Don't have much time left. That is one reason. One reason is we don't have time. Even if we want to take it up, we have 15 minutes left. But why are you praying for adjournment?
My senior has instructed me to do.
Okay.
Kindly, my
This heard Miss
Amber Gohain.
Member Gohain London appearing on behalf of Mr. P. Mohanta Lenin, amicus curiae, who prays for an adjournment. Stop. Otherwise, also due to paucity of time, this matter would not be taken up today for hearing. Hence, let this matter be listed after the week.
Thank you. Much appreciated.
Item number 43, supplementary, your lordship. I'm sorry that I could not attend when the case is called for, your lordship. My only prayer is, lordship, let's fix the matter on 16, your lordship. There's an interim order, your lordship. May I pray that may continue till 16, your lordship.
Okay. There are two matters, no?
Yes, your lordship. Interim order is item number 43, your lordship.
Okay. In 43, interim will continue.
Mobility.
And later on, show the presence of Miss
R. Decker
R. Decker
for the petitioner.
for the petition. The should later on, Miss R. Decker, learned counsel for the petitioner appeared. Stop. And submits that she was on legs in a different court. And therefore she could not appear before this court when the matter was called up for hearing. Stop. And interim order shall continue till next day.
Mobility.